उसके बाद देखते mention था 11 item number है so that in this case your lordship yesterday government has final affidavit your lordship possibly not in the record your lordship might be allowed to bring the opinion of record
May I praise the question? I'm appearing for item number 18 supplementary discussion. 18 supplementary discussion. Actually last month it was regularly listed, but because of shortage of time, as your lordship on last date I have submitted, the matter is very urgent, your lordship. Kindly may be taken Act 2.
Okay.
Complex.
Inform the other side.
Yes. I beg to answer for this thing. I received 1/19.
For what?
Order. Lordship 4/4/24.
When?
4/4/24.
4/4. Orders. Why do you need it for orders on 4/4?
Lordship regarding the land dispute. Regarding the land dispute. After
Next 60.
apply. Wait, later, Lordship, kindly the matter may be passed over for the time being, Lordship.
Yes.
Lordship, can it be passed over for the time being?
Why?
Is it my senior is on late, so
Oh. Not at all. Yes, Mr. Sinha.
yes ma'am
Whether the substantial question of law arises or not, whether the judgment of the first appellate court suffers from perversity for not taking into account Exhibit 6.
Yes, ma'am. That Exhibit 6
What is
Yes.
Exhibit 6?
is an order passed by the assistant settlement officer in rejecting the earlier order passed by the assistant revenue officer about that Khatian of that tenant. That order has been cancelled. Earlier order has been cancelled by settlement officer. But so far as other Exhibit 1, 2, 3, 4, 5 up to 8, my lord, adduced by the exhibited by the defendant, those are about this Khatian and all those records are there.
This was a suit for what?
Suit for
filed by-
declaration of right, title, and interest
By?
by the plaintiff, my lord.
They are the plaintiff.
Yes, they are the plaintiff.
What did they claim for?
For there's a recovery of position, title and recovery of position.
There's a stay order.
No stay order. No stay order. The objection of the trial court has been reversed in the court appeal.
Let us see where the plaintiff is. I have not been able to pick up.
Plain, my lord, I have in the record also. I have not received any plaint also, my lord, in that record.
They have not filed a plaint.
In my copy, there is no plaint, my lord.
Report. Written statement is there. Where is the plain? Madam, it is the first item. So I am not bothered whether your senior comes or not. Okay. I'm not bothered whether your senior comes. If he is not here, don't worry.
I am here.
Yes. What is your case? Tell me. Where is the plaint in the second appeal? Page.
Plant has been kept. Plant has not been added.
Then we dismiss the second appeal on that ground.
Sure.
Go to the
It was
Supreme Court.
one of 30 minutes.
This is not as per the High Court rule.
Yes, my lord, it is there, but original record is there.
So what? Why the plaint has not been filed?
Well, I got type copy of the plant.
মুড়েতে কপি থাকে এই কপি
So exhibit 6 is what document?
Exhibit
6.
6 is the order of the settlement of
by which your
by which
name was brought in.
Yes, and his name was Iktaf. It was put in the original name of my vendor. My vendor's grandfather.
This is Exhibit 6.
I don't buy it. His name was Iktaf of Secretariat, which was kindly included in the government in coalition with the revenue. Hello, in Mark Pollock, second.
So this order of 1967, 66 of the ADC, ARC was interfered with.
Interfered with order dated four 794.
Let us see what does Exhibit 6 say. You have Exhibit 6. Read it. Which is the portion you are referring to? Number 5? Paragraph 5?
Number 5. कासिम अली तरफदार तरफदार 7/6/94 तारीखे এখন দরখাস্ত যেমন দরখাস্ত উল্লেখ করছে গোয়ালপাড়া প্রজাতন্ত্র আইন ও 107 ধারা 1750 62 নম্বর 17 মূলে আইনজীন পদাৰৰ লগতে কাসেম তৰফদাৰৰ নামত খতিয়ান খোলাৰ আদেশ হৈছে আৰু এই মতে তেওঁৰ নাম সদৰ খতিয়ান মূল ঠিকা আৰু মূল জমাবন্দীত আছে গতিকে এই একাইবৰ ৰেকৰ্ডত তেওঁৰ নাম বুক কৰিব লাগে এই সংক্ৰান্তত সহকাৰী বন্দোবস্তি ৰেকৰ্ডত অধিকাৰী ঘূৰি প্ৰতিবেদন দিবলৈ কোৱা হৈছিল জ্যেষ্ঠ সহকাৰীকে প্ৰতিবেদন দিছে জ্যেষ্ঠ বন্দোবস্তি প্ৰাধিকাৰীৰ প্ৰতিবেদন মতেও সদৰ খতিয়ান মূল চিঠা আৰু মূল জবাবন্দীত হৈ কাসেম তৰফদাৰৰ নাম বুক কৰাৰ নিয়ম ব্যতিক্ৰম হৈছে কাসেম তৰফদাৰৰ দাবী কৰা মতে সংশ্লিষ্ট বছৰ সম্পৰ্কে কোনো কাগজ পাতি দেখাব পৰা নাই কাসেম তৰফদাৰৰ দাখিল কৰা যাৱতীয় কাগজ পাতি চোৱা হ'ল বছৰীয়া মাটি সংক্ৰান্তত ফৌজদাৰী কাৰ্যবিধি আইনৰ 107-144 ধাৰাত 93 মোকদ্দমাৰ আৰক্ষীৰ প্ৰতিবেদন মতে দেখা যায় উল্লিখিত 14 বিঘা 1 কাঠা 13 লেচা পৰা 10 বিঘা 1 কাঠা 13 লেচা মাটি শ্ৰী মিনাজ মণ্ডল পটাদাৰৰ আইজিন পদাৰৰ পৰা খৰিদ কৰি ভোগ দখল কৰি খাই আছে উক্ত খৰিদা মাটিৰ পৰা 4 বিঘা মাটি তেওঁ বিক্ৰী কৰিছে আৰু বাকী 6 বিঘা 1 কাঠা 13 লেচা মাটি 4 বছৰৰ আগতে বন্ধক হিচাপে কাসেম তৰফদাৰৰ দিছিল বন্ধকৰ সময়ত উকলি গৈছে আৰু কিন্তু কাসেম তৰফদাৰ দখল এৰি দিয়া নাই এই গাঁও অলপতে জৰীপ হৈছে গাঁও জৰীপৰ সময়ত 225 নম্বৰ দাগৰ নতুন 351 নম্বৰ দাগ গন্তব্য কলমত দখলকাৰ হিচাপে কাসেম তৰফদাৰৰ নাম লেখা হৈছে উপৰোক্ত উল্লিখিত অটাইবোৰ বিষয়ে বিবেচনা কৰি কাজিয়াঘাটৰ 3য় খণ্ড গাঁৱৰ 1 নম্বৰ খতিয়ানভুক্ত 14 বিঘা 1 কাঠা 13 লেচা মাটিত 2 নম্বৰ পাটাদাৰ হিচাপে কাসেম তৰফদাৰৰ ইটাৰ নথৰ তৰফদাৰৰ নাম ভুক্ত কৰাৰ ভূমিলেখে নথিত জালিয়াতি কাৰ্যৰূপে প্ৰমাণিত হয় ভূমিলেখে নথি জালিয়াতি কৰা দখত সংশ্লিষ্ট কৰ্মচাৰীৰ শাস্তি পোৱাৰ যোগ্য উপায়ুক্ত ধুবুৰী কাৰ্যালয়ত থকা সদৰ খতিয়ানৰ পৰা কাসেম তৰফদাৰৰ নাম কৰ্তন কৰাৰ ব্যৱস্থা আৰু ভূমিলেখে নথি জালিয়াতি কৰা দখত দায়ী কৰ্মচাৰীক উপায়ুক্ত শাস্তি বিহাৰ ব্যৱস্থা গ্ৰহণ কৰিবলৈ উপায়ুক্ত মহোদয়ক অনুৰোধ জনোৱা হওক সহকাৰী বন্দোবস্তি প্ৰাধিকাৰী বিলাসীপাৰা কাৰ্যালয়ত থকা মূল চিঠা আৰু মূল জবাবন্দীৰ পৰা শ্ৰী কাসেম তৰফদাৰৰ নাম কৰ্তন কৰিবলৈ সহ বন্দোবস্তি প্ৰাধিকাৰীক কোৱা হওক আৰু ভূমিলেখে নথি জালিয়াতি কৰা দখত দায়ী কৰ্মচাৰীৰ বিৰুদ্ধে
This Kasim Tarafdar was
He was the defendant.
defendant. Father of the defendant or the defendant?
Other of the
Father of the defendant.
সংশ্লিষ্ট কৰ্মচাৰীৰ নাম জনাবলৈ কোৱা হওক মূল চিঠা আৰু মূল
And this order has not been put to challenge anywhere.
it got finally and the learned
And
appellate
kindly
court
see number 10, the Kasim Tarafdar.
কাসেম তৰফদাৰৰ বৰ্তমান আবেদন গ্ৰহণ যোগ্য নোহোৱাত নাপাত্তা
So his name was struck off. And this was not
Accordingly, in Jamabandi, it was reflected.
in which Jamabandi?
The Lordship page,
Exhibit 1?
Yeah.
Exhibit 5?
4, exhibit 4. Second, my remark follows.
The first one is
First one, his name was included.
হুকুমৰ মতে ইমান নতুন ইমান ইয়াৰ তাৰিখৰ 26 নম্বৰ দাগৰ পৰা উত্তৰ পশ্চিম তৰফদাৰৰ But what is the 66 one? 1966, the entry made in 1966 in Exhibit 1 of the defendant's document.
This 6 pendant document, my lord,
Exhibit 1 of the defendant document. Both have been exhibited as one.
Colonel Khatia, but
Mhm.
his name was struck off.
But no, therefore, if you see Exhibit 4, there are two entries.
Yes.
The first entry
In first
pertains
entry,
to
his name was included. In second entry, his name was struck off. As per the order of the assistant settlement of exhibit 6.
I, Judin,
बंदोबस्ती प्राधिकारी हमारे सारी हाथ
and the name of the original owner was brought in.
brought because at that time settlement was not complete. So his name was kept as it. My vendor's father.
And this Poddar person, the sons of the Poddar sold you this 10 bighas of land,
10 figures. After his death.
of which you sold 6 bighas and remaining was 4 bighas.
No, he sold out 4 bighas, 6 bigha remained with me. And this 6 bigha is the soup land.
No, 4 bighas is the suit land.
No.
Exhibit E is the Schedule E is the suit land. Now 6 bighas is the suit land.
Yes.
And 4 bighas was sold by whom? You sold.
By me.
So
by the
you purchased 10 bighas,
I purchased 10 bighas.
of which 4 bighas you sold it to the
Sold out
performer
to
defendant
the
number 2,
performer defendant Rahmatullah.
number 2 and 3.
2 and 3 are the his son, Rahmatullah Akbar. He was earlier he was brought as a
So you
support
sold up to performer defendant number 2 and 3. So remaining was 6 bighas.
6 bighas.
And this 6 bighas was the Schedule E,
Good.
which he entered.
He dispossessed me in the year 1994.
Now, here, the first appellate court did not go into anything else.
He is not uttered about the exhibit 6. Totally silent about the exhibit 6.
And what does
And
the
alleged rent
and
receipt-
what is out here? How does the trial court deal with the issue
Yes, ma'am.
on the question of, let us see, issue number plaintiff, whether the plaintiff was right title over Schedule B land and whether the plaintiff is entitled to it.
My lord, issue number 456.
Page 20.
These issues are taken up together for convenience of discussion. The plaintiff, in support of their case, has exhibited sale deed number 1 of the plaintiff. On perusal of the exhibit 1 of the plaintiff, it appears that 4 sons of late Aizuddin Poddar sold land measuring 10 bigha 1 kata 13 letter to the plaintiff. Exhibit 6 of the plaintiff side, which is the order of the settlement officer, clearly mentions that the name of the defendant was subsequently inserted, and accordingly the same is liable to be cancelled. the defendant did not prefer any appeal against the
Exhibit
order of
6 of the plaintiff, which is the order of settlement, was clearly mentioned that the name of the defendant was subsequently inserted and accordingly the same is liable to be cancelled.
cancelled. The defendant did not prefer any appeal against the order of settlement officer. Exhibit 4-5 of the plaintiff side shows that name of the defendant was cancelled as per the order of settlement.
And the defendant,
On the other hand, the case of the defendant is that he was tenant under Ayuddin Podar possessed the land measuring sponsor, and since last 30 years, the defendant has admitted the title of the Ayuddin. He also admitted 4 bighas of land was sold to performer defendant number 1 by me. By me.
the performer defendant number 1 was sold by the original.
Rahimutullah. Rahimutullah.
No, not you.
No, I sold out.
No, you didn't. You sold out to only performer defendant number 2 and
No, they were the sons of the Rahimutullah.
see in your plane. Kindly come to paragraph number 3. Paragraph number 2 of your plane.
That the plaintiff two, Ayuddin Podar sold 4 bighas of land to performer defendant number 1.
So you did not. Your
Yes.
sold it. You sold at paragraph 5. Kindly see.
The plaintiff sold 4 bighas. Oh, out of total land was 14 bighas.
That is what he is saying. Yeah.
Total land was 14.
So that is what.
Out of that, 10 bighas was sold to me. And
Now
out of
let
that,
us see what
4 bighas
how
was
the
sold.
defendant have admitted the title of Ayuddin. He also admitted 4 bighas of the land was sold to the performer defendant. Of the defendant is that the heirs of late AI executed a fraudulent deed
Yes.
in favor of the plaintiff, whereas the legal heirs had no only right over 4 bighas, 6 later.
Yes.
Because 6 bighas was his.
Yes.
The defendant did not file any case for cancellation of the alleged fraudulent sale deed. Another point to be noted is that Exhibit 6 of the AR clearly mentions that how the name of the defendant was reported as the tenant is not mentioned. Para 5 of Iman, in para 2 of the Exhibit 6, the plaintiff, it is clearly mentioned that the plaintiff purchased the land measuring so and so by the deed of sale, but the names were not recorded as the deed was not surveyed. Therefore, the record was in the name of so and so. It is also contained in how his name was recorded. Exhibit 4 of the states that clearly that he recorded the name of the subsequent exhibit. But perusal it appears that exhibit 11 of the defendant was there's some mistake. Hey, file C or file 8. এই কাগজ এখন and who was this Ayuddin Poddar?
He was the original. My vendor predicted.
Yes, Mr. Sinha. How do you protect the impugn order where Exhibit 6 was not at all taken into consideration, which was the basic fulcrum of the judgment of the trial?
My lord, in that Kotian, the lordship has found that in the year 1966, name of the defendant, father of the defendant were inserted. As a Kotian, it has been recorded. There is under Gwalpura Tenancy Act, that Tenancy Act has been repealed. So suddenly, in the 1994, they have filed a petition before the settlement officer for cancellation of our name and all. Now, power of settlement officer exercised in this regard as an appellate authority or original authority. Application, because there is as per this
Mr.
repeal.
Sinha,
Yes.
you have a very fantastic case in appeal before the Board of Review.
Nah, of course, my lord, but
Not
that,
here.
yes, of course, my lord. That has not been done, my lord. I know, my lord. So here the settlement officer.
Here the trial court or the first appellate court gave you the entire right on not the right. They say that you are a Khatian tenant, or that there is a Khatian issued, or you are a tenant, a non-evictable tenant, on the basis of Exhibit 1.1 of your document.
Yes, my lord.
But without taking into account that Exhibit 1.1 has already been set aside by this settlement officer.
Yes, that is my lord. Whether it is as a my lord, the original code as an appellate code, my lord. Because the earlier my name was recorded by the ARO, Assistant Revenue Officer, and appeal lies before the settlement officer or deputy commissioner. But they have not filed any appeal. Whether that order is maintainable in law. Only this is the only defense I have now at present.
Verification.
Yeah, because because he has the power on the appeal. As in the appellate revenue code, he has that power to cancel my original AR order.
Understood.
Yes,
Everything is understood, but how do you protect the first appellate court's order? It's absolutely incourageous order, taking into account that when you want to pass an order by which you want to set aside the order, you have to take care of Exhibit 6 cannot be taken into account.
It is the foundation itself.
That's the fundamental. Isn't that what has been mentioned in paragraph 15 of the judgment in Santosh Hazare? It categorically says that if you want to set aside, very well, you have the power to set aside, but you have to assign reason why. He went into a document which have been held that it is overridden by Exhibit 6.
Yes,
So
of
you
course,
have
no
to
appeal,
say,
no appeal the defendant has filed.
can't help it.
But if the judgment has been passed on the
It's a very
basis of
sad thing that it has been very poorly done by the first appellate court. And you did not raise that issue in your written statement.
No, only simple denial.
And also one more thing is to be there, that they say they filed this suit, that they have been dispossessed. Entire, my lord, the evidence and all, there is no date of dispossession. No date, only said the last part of 1994, last part of 1994. There's no date of dispossession. That on such day, they have dispossessed her. No court has also come to arrive at a finding in this regard, my. They have prayed for recovery of position and title. Now, immediately, the filing of appeal also because they have come for the suit. So, the revenue authority was not approached by their defendant perhaps because suit is pending.
That is okay, but
No,
that I also don't find. Neither an issue was framed.
Yeah, no.
But have you taken any ground out there that you did not dispossess? Is it your claim that you are not dispossessed, or is it the claim that you are the owner? Kindly see, declared in collusion with the Iman and the contents of the denied.
The written statement, they have denied it.
The suit plan being in agriculture,
Simple
the
denial.
sale deed is not
Hmm?
valid under the
Simple
provisions
denial.
of law. The remains of the part of Paragon is denied, and the prisoner for recording the name was rejected by the ASO where the plaintiff had no possession. See, he didn't even claim adverse possession,
There was no contract.
which is the tenant land of the defendant, and the defendant had acquired right, title, and interest over the said land by possessing of its own against all openly and adversely against all others. Engineered the plot from grabbing the land of the defendant, the plaintiff acquired no right, title, or interest by the fraudulent purchase on the area, which is the tenanted land of the defendant, and the defendant have acquired right, title, and interest of the said land by possessing his own right against adversely. It is denied that the defendant, along with the other man, dispossessed the plaintiff in the later part of Iman. Hello. Let me dictate. Look. This is an appeal under section 100 challenging the judgment and decree passed by the learned First Appellate Court dated 13/4/2009, passed in title appeal number 79/2006, whereby the appeal was allowed, thereby setting aside the judgment and decree dated 30/10/2006, passed in title suit number 183/96. Judgment and decree passed by the civil judge Dhubri, civil judge for short the First Appellate Court, and by setting aside the judgment and decree dated 30/10/2006, passed in title suit number 183/96 by the court of the Munsif number 2 Dhubri. This court, by an order dated 27/11/2009, had admitted the instant appeal by formulating a substantial question of law. However, when the instant appeal was heard, the said substantial question of law formulate did not arise, and as such, this court, after hearing the parties, framed an additional substantial question of law on 19/3/2024. That is, number 2, whether the judgment of the learned First Appellate Court suffers from perversity for not taking into account Exhibit 6? Question mark. For deciding as to whether the said substantial question of law arises in the instant appeal, this court, in brief, would like to take note of the relevant facts which led to the filing of the instant appeal. One, what is his name? AIZJU. What is the spelling?
AIJUDDIN. Aizuddin Poddar.
Poddar was the owner of 14 bighas. One Aizuddin Poddar, since deceased, was the owner of a plot of land measuring 14 bighas, 1 katha, 13 letters, covered by dark numbers 224, 225, 226, and included in patta number 98/17. Of village Kozaikota, Part 3. Within Revenue Circle Bilasipara in the district of Dhubri. The said land was more specifically described in Schedule A to the plain. Of title suit number 183/96. 183.
Yes, ma'am.
During the lifetime of late Aizuddin Poddar, he sold 4 bighas of land to one Rohimuddin, the performer defendant number 1. The said land have been more specifically described in Schedule B. After the death of late Aizuddin Poddar, his 4 sons, namely late Jabbar Poddar, late Majid Poddar, Abdul Haki Poddar, and Mokaddas Poddar, Mokaddas, Mokaddas Poddar, executed a registered deed of sale bearing deed number 1776/83, dated, what is the date?
Dated 27/1/1986. Dated 27/1/1986.
Thereby transferring 10 bighas, 1 katha, 13 lecha of the land in favor of the plaintiffs. Plaintiff or plaintiff?
Plaintiff. There are 2 brothers.
Plaintiffs. The said land has been more specifically described in Schedule C to the plaintiff. The plaintiffs thereupon, by the deed of sale, bearing deed number. Any idea?
No idea.
Thereupon, the plaintiffs thereupon claims in the plaint that 4 bighas of land out of the Schedule C land was transferred to the pro forma defendant number 2 and 3, and possession was duly delivered. The said land have been more specifically described in Schedule D to the plaint. Therefore, on the basis of the sale, the plaintiff became the owner. The land remaining with the plaintiff was 6 bighas, 1 katha, 13 lechas. Which the plaintiff claimed that the plaintiffs were in possession thereof. This land, measuring 6 bighas, 1 katha, 13 lechas, was fully specifically described with definite boundaries in Schedule E to the plaint. It is the case of a plaintiff that the defendant, in the last part of 1994, trespassed into the said Schedule E land and dispossessed the plaintiff. Under such circumstances, the suit was filed seeking declaration of right, title, and interest as regards the Schedule E land for recovery of khas possession of the Schedule E land, for permanent injunction restraining the defendants from alienating, transferring the Schedule E land to anybody, or get correction of the record of rights for the Schedule E land semicolon, a declaration that the plaintiffs are entitled to get mutation of their names in the Schedule E land, etc. The suit was contested by the principal defendant by filing written statement. Various preliminary objections were taken as regards the maintainability of the suit. It was duly admitted that Ajuddin Podar, since deceased, was the owner of the land measuring 14 bighas, 1 katha, 13 lechas in Dag number 224, 225, 226, Khatian number 98 in village Kazarkota, part 3, Toza number 5 of Sopor, and Kaz and bracket Quds estate. And the records were entered, entering the name of Qasim Ali, showing possessor of the land measuring 6 bighas, 2 katha, 8 lechas in Dag number 225, and the land measuring 1 bigha, 3 katha, 19 lecha in Dag number 226, totaling to 6 bighas, 1 katha, 7 lechas out of 14 bighas, 1 katha, 13 lechas. At this stage, this court finds it relevant to mention that the said statement as regards the calculation of the as regards the measurement of the land does not seem to be accurate, taking into account that adding 6 bighas, 2 katha, 8 lecha in dark number 225 along with 1 bigha 3 katha 19 lectures in dark number 226, the total land comes to 8 bighas, 1 katha 7 lectures, and not 6 bighas, 1 katha 7 lectures, as claimed in the written statement. It was further mentioned in the written statement that late Izzuddin Poddar, at the time of his death, only left behind 8 bighas, 0 katha, 6 lectures. And out of the said land, the performer defendant number 1 was possessing 4 bighas. However, fraudulently, the sons of late Izzuddin Poddar transferred 10 bighas, 1 katha, 13 lectures in favor of the plaintiff, although they had the right only as regards 4 bighas, 0 katha, 6 lectures. It was also mentioned that the name of the defendant was recorded as tenant for 4 bighas, 2 katha, 8 lectures in dark number 225 and 1 bigha, 3 katha, 19 lectures in dark number 226, which was prepared in the year 1967 during the lifetime of Izzuddin Poddar. In paragraph number 16, it was specifically mentioned that the transfer of the Schedule C land in favor of the plaintiffs was a fraudulent sale deed, where inasmuch as the seller had no right, title, or interest. The defendant further stated that the plaintiff acquired no right, title, or interest inasmuch as the defendant had acquired right, title, and interest over the land in their possession by their own right against all, openly and adversely. It was also mentioned that that it was also mentioned that the question of dispossession of the plaintiff on 1994 does not arise, inasmuch as the plaintiffs were never in possession of the suit land. So, on the basis of the pleading, as many as 6 issues were framed, which included issue number 4 as to whether the plaintiff had any right, title, and interest over the schedule land, and as to whether and issue number 5 as to whether the plaintiff is entitled to the decree as prayed for. From the record, it reveals that on behalf of the plaintiff, 4 witnesses were examined and 6 documents were exhibited. On behalf of the defendant, 6 witnesses were examined and various documents from Exhibit 1 to Exhibit Core 5, or bracket 5, was adduced. The learned trial court, by judgment and decree, decreed the suit in favor of the plaintiff. In doing so, the learned trial court decided the issue number 4, 5, and 6 together and came to an opinion that the plaintiffs had right, title, and interest over the suit land, more particularly the Schedule E land, on the basis of the deed of sale bearing sale deed number 1776/83, Exhibit 1,
dated 27/1.
The learned trial court further came to an opinion, further observed that in view of Exhibit 6, which is the order of the settlement officer dated order dated
4794.
4794.
94.
The defendant's name was duly struck off from the record of rights, and there was no appeal filed there against. The learned trial court further came to an opinion, further observed that the deed of sale in favor of the plaintiff, that is Exhibit 1, was never challenged by the defendants. In addition to that, the learned trial court also came to an opinion that the exhibited document move, particularly the defendant document number 11, defendant exhibit number 11, on the basis of which the defendants claimed to be in possession, was pursuant to filing of the suit. On the basis of that, the learned trial court decreed the suit in favor of the plaintiff, declaring that the plaintiffs have right, title, and interest over the Schedule E land, that semicolon, that the plaintiffs are entitled for a decree of khas possession by evicting the defendants from the Schedule E land, as well as a decree for permanent injunction restraining the defendants from alienating the Schedule E land. The other reliefs which were claimed for were not granted. Being aggrieved, a judgment and dated judgment and decree dated iconic. Judgment and decree dated 30/10/2006. Being aggrieved, the defendant, number 1, preferred an appeal before the learned first appellate court, which was registered and numbered as title appeal number 79/2006. The learned first appellate court by the judgment and decree dated 13/4/2009, allowed the appeal and dismissed the suit. The reasoning so given by the learned trial court, first appellate court, was on the basis of Exhibit 1(1) of the defendant, wherein 1(1) of the defendant, without, however, taking into account Exhibit 6, by which the settlement officer, by the order dated number 2 had struck off the name of the defendant. Being aggrieved, the instant appeal has been filed, and as already stated herein above, the substantial question, and I just stated above, the appeal was admitted, and this court, by an order dated 24/3/2020 and 19/3/2024, had framed an additional substantial question of law. Next. During the course of today, when the matter is being taken up, both the counsels duly address on the substantial additional question of law, which was framed by this court on substantial question of law, framed by this court on 19/3/2024, which have been duly heard and considered. In the backdrop of the above, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Santosh Hazare versus Purushottam Tiwari, reported in 2001 3 SCC 179. The said judgment not only is relevant for the purpose of the declaration so made as to what constitutes a substantial question of law, but also how the first appeal court should decide the first appeal. Taking into account that the first appeal is a valuable right of the parties, and unless restricted by law, the whole appeal is open for rehearing both on questions of fact and law. Paragraph 15 of the said judgment, being relevant, is quoted herein below. Next. From the above quoted judgment, it would be seen that there is no quarrel with the proposition that the first appellate court would be within its powers to set aside and or reverse the judgment and decree passed by the trial court. However, in doing so, the first appellate court must come into close quarters with the reasoning assigned by the trial court and then assign its own reasons for arriving at a different finding. The judgment of the appellate court must therefore reflect its conscious application of mind and records findings supported by reasons. In the backdrop of the above, let this court decide as to whether the substantial question of law so formulated arises in the instant appeal, is involved in the instant appeal. A perusal of the judgment of the learned trial court would categorically show that the learned trial court based its decision on issue number 4, 5, and 6 primarily on the deed of sale bearing deed number 1766/AN dated 1983, Exhibit 1, and Exhibit 6, which is the order of the settlement officer, thereby striking out the name of the defendant. The learned trial court have duly taken note of in its judgment that the defendant, after its name have been stricken out from the record of rights, White Exhibit 6 did not challenge the same in any other proceedings. The learned trial court further came to a finding that although the defendant have alleged that the sale deed was fraudulent, a sale deed, that is Exhibit 1, was a fraudulent document, but there was no mention, but there was no challenge to the said deed of sale. However, if this court takes note of the judgment of the first appellate court, the first appellate court, it would be seen that the first appellate court did not address the said issues, address the reasons which have been assigned by the learned first trial court, and based its decision on Exhibit 1.1 of the defendant, which no longer exists in view of Exhibit 6. There was no reasons why Exhibit 6 was not considered. The above aspect categorically therefore shows that the learned first appellate court did not take into account an evidence which would otherwise have changed the course of the proceedings. And this very aspect is a facet of perversity, which is writ large in the judgment passed by the learned first appellate court. Accordingly, in the opinion of this court, the substantial question of law so formulated is duly involved in the instant appeal, for which the judgment and decree passed by the learned trial court, first appellate court, dated 13/4/2021, 4/2009 entitled appeal number 79/2009 is set aside and quashed, and the judgment and decree dated 30/10/2006 passed entitled suit number 183/90/96 by the court of the learned Munsif number 2 Dhubri is restored. This court further quantifies the cost in the instant proceedings at rupees 11,000. In addition to that, the plaintiff herein would be entitled to cost throughout the proceedings. The LCR be returned.
Cost may be reduced. They are villager matter. Cost may be reduced something.
No. That cost has to be given. Minimum. This is the minimum cost of a suit appeal. 11,000 is he has paid court fee. This is not for that repetition cost. This is a cost which has to be given as cost of proceeding. This is in fact mandatory in BF 35. All proceedings here.
Public.
Daughter, my lord, after the death of the father, my lord, daughter claimed share of that land, my lord. And the planet trial court below, my lord, it in my favor. The partition was allowed, my lord. And subsequently, title appeal was filed. In that title appeal was, my lord, against me. My subsequent question of law, page 7.
What is it?
Here, my lord, whether defeat in formal suit filed by the plaintiff on the basis of the oral gift made in her favor by her father can prevent the plaintiff from filing a subsequent suit on the death of her father, claiming her right and partition in respect of her share of the father's
Mr. Counsel, I am only going to hear the substantial questions of law which are already there formally.
yes.
Now tell me those two substantial questions of law, right? Where is the plane?
Late, my lord, page starts from my lord, page 40.
You are the plaintiff,
Yes, plaintiff.
Karim Nessa.
Yes.
What is this LA Sarik?
Lordship,
What is LA Sarik in your plane?
L L Latmun L my lord, pace, my lord.
Kindly come to paragraph number 4. Page 43. In view of the fact of reproducing their father, predeceasing, I think predeceasing their father by Solemuddin and Kotsaya, their legal heirs have become L.A. Sarik. What is that?
Become a legal heir maybe or name
In this way, on the death of their father, the plaintiff had become 1/12 of the share of demand.
extend to it, my lord, judgment of the trial court.
So the trial court gave it in your favor.
Yes, my lord.
Appellate court,
Appellate court, my lord, in their favor, my lord. That's-
why?
Because, my lord, learned court below held that, my lord, already I have
Had taken
defended-
into account 152(3) of the Mohammedan law.
That, my lord, your lordship, there was a query, my lord, from the court. Without partner, LA Sarif means.
Eh?
LA Sarif means, my lord. LA Sarif, that was the word, my lord, means without partner. In Arabic,
It's okay. Now appeal.
appeal, my lord.
Where
Appeal,
is
my
the
lord.
appellate court judge?
Appellate court judgment, my lord, start from, my lord, nine.
Yes. Now, what are the substantial questions of law?
substantial question of law method, Pierre Mallard, page 7, my lord.
Forget about 7.
Page 7.
Two
of-
substantial questions of law were framed on 10/1/2007. Whether the ground or rejection of mutation can confer title of the property. How does that have any relevance? Whether oral gift under Mohammedan law can be held to be proved when the parties in whose favor the alleged gift was made fail to prove the three golden principles of making oral gift of Mohammedan law: declaration, acceptance, and delivery of possession.
That is it, on their part. They have already admitted. I also admit my brother have received that all by way of my gift. That is appreciation.
Then
But
what is this substantial question of law?
that was framed at that.
Well,
But-
and more particularly, if you see section 152(3), you see when, and this is the second round.
Second one, but that was the different issue, my lord.
Understood.
Yes, my lord.
But at that stage only, you see, you filed a suit against your father,
Yes, my lord. Yes, my
stating that this was the land which was gifted to you.
Yes, my lord. Correct.
Your father opposed it. Against it, the suit went in your favor. There was a gift. When the appeal was filed out there, in the appeal, the specific stand which was taken is this entire land was gifted to the sons,
Yes, my lord. There are four.
and you were only given, your husband was only Hatim Ali or something, was only given 1 bighah, 2 lectures or land or something.
But that is different aspect, my lord, because there are four schedule, my lord. A, B, C, D. Out of them, my lord, landed court below, trial court, my lord, decreed the suit, my lord, in decree for degree C and D. Because where they are, my lord, in possession, because we have not received the title of the. That was the issue, subject matter in the earlier.
Understood.
Yes, my lord. For
But the
it-
issue
Yes.
that there was a gift
Give, my lord.
in favor of the sons
Yes, my lord.
has
Now,
already attained finality in 1989.
18, that is, my lord, that is by way of gift, my lord. But here we need the partition share of the property, my lord.
Understood.
Yes, my lord.
So there already the finding that there was a gift in favor of the sons was already there.
But earlier, my lord, that was there, my lord. But after the death of our father, my lord, we have claimed it because there is no bar, my lord. Because this is this schedule is different schedule C and D. Only, my lord, we will able to, my lord, receive only, my lord, one katha, two katha, 14 less only.
Understood. But entire land has been gifted.
Gifted.
Now they say
But they
if
cannot.
it is a case of joint possession,
But they cannot be able to prove it, my lord, because
what is required to be proved?
by the defendant, my lord, because they have
The
not-
defendant, the defendant number, witness number 1 categorically said that yes, this was gifted.
it is, but not partition the land. That is also
What is their partition is required? They have got their names mutated.
mutated. But
Then
our portion of the
What
land
is
will-
required? Have you got the Mohammedan law with you? Or are you arguing without the Mohammedan law? এখন দিদি একটু মোহাম্মদান law খালি উল্লেখ Mr. H.
Yes.
Das.
taking, my lord, receiving and it is
Ah,
sufficient, my lord.
Give him section 152 or 51. 52.
Immovable property.
লেখো the instant appeal.
The delivery of possession of immovable property, my lord, here, where donor in possession a gift of immovable property of which the donor is in actual possession is not complete unless the donor physically departs from the premises with all his goods and chattels, and the donee formally enters into possession.
152.3.
Where donor and donee both reside in the property, no physical departure or formal entry is necessary in the case of gift of immovable property, in which the donor and the donee are both residing at the time of the gift. In such a case, the gift may be completed by some overt act by the donor indicating a clear intention on the part of the transfer position, and to donor indicating a clear intention on the part of the transfer position, and to divest himself of all control over the subject of gift. Here, my lord, there is no bar, my lord, for my lord, claiming the my lord, partition of the land, my lord. Because
They
once-
say their specific standing. Where is the question of partition? This land was gifted by the father
Father, my lord.
to his 6 sons.
Yes, my lord. But that my lord, one
That is
person-
proved on the basis that they have done an overt act of mutation.
may read my lord, only PW, my lord, official witness, my lord. But he state, my lord.
What is that?
PW 5.
What does it say?
The
Why
last
should I look into all these things?
logic,
Why should I look into that evidence?
because it says about the partition.
No, this is not. I am not sitting in first appeal.
Yes.
The substantial question of law which has been given out here is there because the finding of fact arrived there that yes, there was an overt act to that effect that there was a mutation being carried out. Kindly see the finding of fact of the trial of first appellate court.
But where my lord mentioned of only about the Schedule A land, my lord. That
Schedule A
portion of
land,
that-
yeah. Kindly come to paragraph number 15. On perusal of the facts and circumstances, it is found that during the lifetime of so and so, the father of the party settled his properties among his sons by way of gift, and the defendant, after possessing the suit land since 1971. It has been found that the appellant defendants, by accepting the gift by their father, peacefully occupying the land of their shares separately, and the appellant they are also admitted that their father, late so and so, purchased 4 kathas of land in dark number so and so and 2 kathas of land in so and so in the name of Hatim Ali, the husband of the Imam, and this area. These are findings of fact.
But we have not received that land.
You have not received, that is a different thing. I'm
Yes,
not
ma'am.
concerned. You go ahead with this. You have not received, you ask for possession, do whatever you
Brother.
like. This is a land which have been purchased in the name of Hatim Ali.
But that is mentioned, but there is no, my lord, whisper about whether we are in possession or whether we have received it, my lord. That's why, my lord.
There is a finding of fact. How can
that
this
is
court
mentioned.
disturb?
This is absolutely, my lord, wrong statement given by, as my plaintiff given me, my lord. Last night, my lord, he has told me that no more. We have, nothing has been purchased in our name, and no, we have not received anything.
Very
Sort
well.
of that. Because that's why we have filed the case.
Very well. So
Yes.
they should have got hold
Only
of
we have
you
lost
at
the
that.
case.
They should have
Mutation case filed, my lord, that were all dismissed, my lord.
all your 4 mutation applications have been dismissed.
Dismissed, my lord, because
Yeah.
my lord, that is correct. But no appeal was filed, my lord. No appeals were filed, my lord, earlier. But so far, this, my lord, is concerned, my lord, we need one portion of the land, and that is already decreed in our favor. That is only 2 kathas out of 2740 because, my lord, only that is I have seen, my lord, Schedule C and D. That is, my lord, 2 katha 14 lesser only. Here. And then here.
Yeah, your father died in 86.
Yes.
And their mutation was done in 1971.
71. DW1, my lord, I want to read, my lord, DW1, cross.
No, no, their mutation was done in 1971.
13,371 তারিখ করণ
All the land,
all the
27 and 21.
yes 78 পাট্টা 607 দাগ নাম্বার সঞ্চয় দান হিসাবে নামজারি করে মোর পিতার নাম সমীর
No, no, no. I'm asking you whether the mutation was done in 1971.
71
Both the pattas.
both the pattas, but that portion has not been handed over to her
Two.
to the malad this plaintiff malad.
So plaintiff is okay, but they got their mutation done
Yes, malad.
during the lifetime of the father.
Father.
So
They have mentioned in this way, malad.
there's nothing wrong.
Where in this malad that's from
Not necessary. Enough.
in 37th tarikhe করণ
The instant appeal under section 100 of the Code of Civil Procedure, for short the Code 1904, is directed against the judgment and decree dated one 8/2006 or 25/7/2006, passed by the court of the civil judge Borpeta, entitled appeal number 57/2005, passed by the civil judge Borpeta, for short the first appellate court, for the sake of convenience referred to as the first appellate court, entitled appeal number 57/2005, whereby the judgment and decree dated (26/8/2005), passed in title suit number 31/03 by the learned Munsif number 1 Borpeta, for short, for the sake of convenience referred to as the learned trial court, was set aside and quashed. This court, by an order dated 10/1/2007, admitted the instant appeal by formulating two substantial questions of law, which reads as under. For the purpose of deciding as to whether the said substantial questions of law do arise in the instant appeal, are involved in the instant appeal, this court finds it relevant to take note of the brief facts which led to the filing of the instant appeal. The appellant herein, as the plaintiff, instituted a suit being title suit number 31/03, claiming her share, claiming declaration of her share as per the Mohammedan law in respect to the lands fully described in Schedule A, Schedule B, Schedule C, and Schedule D to the plaintiff, as well as for partition and for permanent injunction. The cause of action for which the said suit was filed was that after the judgment and decree passed against the plaintiff, by the First Appellate Court in title appeal number 30/1989, which was confirmed by this court in second appeal number SA number 191/1989. The defendant was trying to dispossess the plaintiff from her possession of the suit land. Pursuant to the filing of the said suit, the defendants collectively filed a written statement wherein the rights of the plaintiff to claim any partition or share in respect to the scheduled land was denied. It was a specific case of the defendants in their written statement that the father of the plaintiff as well as the defendant, number 1 to 6, gifted (21 bighas, 0 katha, 14 lectures of land by oral gift, covered by DAG number 331, 333, 352, 365, 362, 379, 383, and 775. And thereupon they have been possessing the said land in equal shares. It was also the specific case of the defendants that in respect to Pata number 78, land measuring 27 bighas, 0 katha, 1 lecha, was also donated by the father of the said defendant numbers 1 to 6 to his 6 sons. And the defendants duly accepted the gift and have been in peaceful possession thereof, equally distributing amongst themselves. It was also the specific stand that the father of the plaintiff as well as the defendant numbers 1 to 6 purchased 2 kathas of land under DAG number 82 and 2 katha 3 lectures of land under DAG number 698 of village Kalabonga in the name of late Hatim Ali, which was the share of the plaintiffs, and the said land is in possession of the plaintiffs. It was also stated that the plaintiff had no right, title, and interest over the suit land. Apart from that, the plaintiff filed as many as 5 applications seeking mutation of her name in respect to the suit land, which was rejected by the learned SDC Bornogor Circle by passing an order dated 23/2/1989, and thereupon the plaintiff did not file any appeal against the said order. Pursuant to the filing of the said suit and pursuant to the pleadings, the learned trial court framed as many as 6 issues. Issue number 4 relates to as to whether the plaintiff had right, title, and interest by way of inheritance to the extent of her share as per Mohammedan law as described in the schedule to the claim. The trial court, while deciding the said issue, duly took into account the evidence of the defendant witness number 1 that late Samiruddin, the father of the plaintiff and the defendant, had bequeathed his property in favor of his 6 sons, and they are in possession of the suit land in equal shares. However, the learned trial court without considering that pursuant to the gift made in the year 1971, the lands have been duly mutated in favor of the 6 sons of late Samiruddin, which was evidence as per exhibit 4 to Gho and Ngo to Jo, held that the defendant failed to prove that there was declaration, acceptance, and delivery of possession. It was also observed that mere mutation of suit land does not confer any right, title, and interest. And as such, came to an opinion that as there was no valid gift, the plaintiff was entitled to her share as per the Mohammedan law over the suit properties. Being aggrieved, the appeal was preferred by the defendants before the court of the civil judge Borpeta, which was registered and numbered as title appeal number 57/2005. The learned first appellate court after discussing the materials on record came to a categorical finding of fact that during the lifetime of late Samiruddin, the father of the parties settled his properties amongst his sons by way of gift, and the defendants were possessing the suit land since 1971. It was also opined by the first appellate court that the defendants, by accepting the gift by the father, peacefully have been occupying the lands of their share separately. It was also opined that the defendants admitted that their father, late Samiruddin, purchased 4 kathas of land in Dag number 82 and 2 katha 3 lechas of land in Dag number 698 of village Kalabhanga in the name of late Hatim Ali, the husband of the plaintiff. And this 1 bigha, 1 katha 3 lechas of land was given to the plaintiff as her share by late Samiruddin. It was therefore opined that the plaintiff had no right and title over the remaining suit land. On the basis of the said opinion, the learned First Appellate Court decided the said appeal in favor of the defendants, thereby allowing the appeal and dismissing the suit. Being agreed, the present appeal has been filed. In the backdrop of the above, this court have heard Mr. H. Das, the learned counsel, appearing on behalf of the appellant, who urged that a substantial question of laws which had been formulated by this court on 10/1/2007 are duly involved in the instant appeal. The submissions so made have been duly considered. In the backdrop of the above, this court now finds it relevant to take note of as to whether those substantial questions of law so formulated are actually involved in the instant appeal. The first substantial question of law is as to whether the ground of rejection of the mutation can confer title of the property. In the opinion of this court, the said cannot be said to be a substantial question of law involved in the instant appeal, taking into account any decision rendered in the said question would not affect the decision in the proceedings. Further to that, this court have also duly taken note of that the learned First Appellate Court did not decide the appeal on the basis of rejection of the mutation application filed by the plaintiff. Rather, the learned First Appellate Court had decided the appeal on the basis of the evidence on record to the effect that the defendant, that the late Samiruddin during his lifetime in the year 1971 had duly gifted the suit land in favor of the defendant numbers 1 to 6, and thereupon during the lifetime of late Samiruddin, the lands were mutated in favor of the defendant number 1 to 6 who have been occupying separately, and enjoying their lands by having separate possessions, in separate possessions. Therefore, the said first substantial question of law so formulated in the opinion of this court cannot be regarded as a substantial question of law involved in the instant appeal. The second substantial question of law so formulated is whether the oral gift under the Mohammedan law can be held to be proved when the parties in whose favor the alleged gift was made failed to prove the 3 golden principles of making oral gift of Mohammedan law, that is declaration, acceptance, and delivery of possession. The said question so formulated in the opinion of this court is a question of fact and cannot be said to be a substantial question of law involved in the instant appeal, more so in view of the categorical finding of the The more so when the question as to whether there was declaration, whether the gift was accompanied by declaration, acceptance and delivery of possession being a question of fact. It is also seen that the learned First Appellate Court in paragraph number 15 of the judgment have categorically held that there was a valid gift. This court have also taken note of section 152 of the Mohammedan law, which also stipulates, and from the materials on record and the findings arrived at by the learned First Appellate Court, it is seen that the said gift so made was in consonance with the said provision. Under such circumstances, this court does not find any substantial question of law involved in the instant appeal, for which the appeal stands dismissed with a cost of rupees 11,000, with the cost quantified at rupees 11,000. Further to that, the appellant's hearing, the respondent hearing shall also be entitled to cost throughout the proceedings. And if you go to it, like to healthcare returned it. Registration. What are these? So many?
First, we have one is second appeal and second is testamentary.
Why are testamentary cases here?
Because between the same parties regarding the will, regarding the one part of the plan of the second appeal. The dispute between
That can be decided later on. First, we'll decide the second appeal.
concurrently.
Huh?
Concurrently.
No. I'll decide the second appeal first.
First and second appeal. That will
As
be-
to whether these questions of law arises or not. If not, matter goes.
There are,
Whether first is order 41, rule 31.
yes, then we have-
Below was in permissive possession of the suit land on the basis of no evidence. Whether both the courts below misconstrued the law of evidence relating the claim of the plaintiff appellant over the suit land by prescriptive adverse possession. Whether both the courts below committed an error in declaring title of the suit land in favor of the defendants in the counterclaim arising out of remand in absence of positive evidence. Whether both the courts below committed an error in law ignoring section 27 of the limitation in absence of delivery of possession by auction purchaser to stand. How many appeals are there? Means RSA?
one.
One. There is a counterclaim?
Yes.
It's against the counterclaim decree, not against the main
Yes.
suit.
Yes. Counterclaim was decreed, Miller.
Not the suit.
Not
Suit was filed by whom?
my
Your suit was dismissed.
Yes.
And the counterclaim was decreed.
Yes.
So against the suit being dismissed, you have not filed an appeal.
not
Okay. So your suit, your rights have attained finality to the effect that the dismissal of the suit.
my lord. If I claim the first one, my lord, this second appeal. If I treated as the first appeal is against my dismissal, then it is survived in second appeal. If I relinquish that right title, her right title, it is in counterclaim, then it is against me.
Yes, show me now.
My lord,
Where's your plane?
plain my lord, at page my lord, 46.
So you have made up your mind. This appeal is against the counterclaim or the suit. Which one?
In that case, my lord, we'll have to go to again, my lord.
I'm not on that. I'm asking you where. Then I'll not go to, because one appeal will arise. We have to decide only one.
Then
We
my
are
lord,
not going to decide both
against counterclaim.
against the counter.
Again.
So we are not going to look into the suit. But only we'll have to see what is your claim in the suit. Declare defendant has no title over here. Plaintiff acquired title over the suit land. Plaintiff acquired title of the suit land over what?
Over my lord, schedule land. On
To the
Kotha,
entire one katha 17.5 letters, permanent injunction. So we have to hold that the court have rejected your right over
right?
claim of right over one katha 17.5 one
Yes,
fourth.
adverse question. That claim was on the basis of adverse question.
Who's yours?
Yes.
So your claim for
No,
adverse
rejected.
possession is gone. Okay. Now let's see the counterclaim.
My lord,
Written statement on behalf of the man and the counterclaim.
before that, my lord, of the details of regarding the inheritance, let us kindly see the page 9, my lord, from small paragraph of the judgment.
An eviction of the plaintiff. Okay. Now there has been a declaration of right title and interest in favor of the defendant.
Yes.
Let's see the counterclaim. What is the basis? you admit that the defendant number one and two are the owners of the land in your claim
By way of purchase method,
by way of purchase?
we have challenged that particular purchase method. They purchased from the son purchaser who never came to
No, no.
possession.
It's a different thing. Possession or not, that is not on question. But you admit the ownership,
My lord, yes,
you have to
yes, ma'am. There, document is there, my lord.
admit the ownership.
Yes,
Now, once you fail to prove your adverse possession and your claims, you have not filed an appeal there against.
I failed adverse position in my favor, ma'am. But they failed to declaration on the basis of title within 12 years. They also failed.
No. They don't need to.
They filed a counterclaim, my lord.
Why?
Necessary.
They filed a counterclaim.
I did a recovery position.
Yes.
Recovery position is there.
So they have asked for right and for first possession.
Yes, ma'am.
Then
First position. First position, they will have to prove that within 12 years they are in position with title method.
Hmm.
They are no title method because on stranger who purchased the land on auction purchase, he never took possession, my lord. On in 76 he purchased auction purchase, and the husband of the vendor, husband of the defendant, he purchased from the auction purchaser in the year 1989. Maybe there is no pleading that 676 million who are in position, whether their vendor is possessing or not.
I'm not concerned with that. We are not concerned with the possession or not. No, I'm not. I'm simply asking you a question. Once you fail as regards your claim for adverse possession,
Yes, ma'am.
any person can file on the basis of title. You don't require possession.
No, my lord. As per article, my lord, 2 section, my lord.
Yes.
My lord, 64.
How is 64 comes?
Article,
Article 64 won't come. Article 65.
Article 65, my lord. First, I am reading 64, my lord. Both are for adverse possession.
Yes.
For possession of immovable property based on previous possession and not on title, when the plaintiff while in possession of the property has been disposed, 12 years. So it is done, my lord. It is not on my paper because that is done. But now, for possession of immovable property or any interest therein based on title, 12 years. When the possession of the defendant become adverse to the plaintiff.
So your possession has to be adverse 12 years.
Yes.
But you failed that. Suit.
No, not for my suit for declaration of my adverse position and becoming a title holder. It is 64 million. But their case, they are within 12 years. Although they are title holder, but they
No, that cannot be 64. It has to, your suit is also under 65.
no, my lord.
Your suit is also 65 based on adverse possession, you have acquired the title. That is not 64. This is 65.
65. Even if they are
64 will come when you have been dispossessed.
dispossessed.
So 64
Yes,
won't
yes.
come to
Yes,
yours. You come under 65. His case also is based on title being will come under 65.
65.
So
They will-
your case therefore has to come qualify that you have been adversely possessing. And there you failed in your suit.
my lord, but
Oh,
suit is
your appeal
failed.
goes.
My suit failed, my lord. But when they are counterclaim, when the possession of the defendant become adverse to the plaintiff,
Yes, that is it. So you fail. The finding out there makes it clear that you have possession is not adverse. And when the possession is not adverse, he is entitled to. A person can very well, I can very well file a suit against anybody who is there for 100 years. That is not material. But the question is whether his possession is adverse. The day it has become adverse, it is it. You fail to prove all what is required.
my lord. But if there is no suit in my favor, then counterclaim will. The suit is not there, made. My suit is not there. Their counterclaim is there. So, my lord, they will have to prove in their own merit, my lord. They will adduce all the evidence regarding their,
But you have admitted he's the owner.
he is the owner, my lord. If I claim a first person, I must claim that he is owner, but his right is extinguished. His right is extinguished on the 12th completion of the 12 years.
From the date it had become adverse to you. From the date it had become
Yes.
adverse.
Yes, my lord. One part.
Your ownership was adverse to your grandfather.
No,
Your grandfather, that person, what is his name?
Ramakanta.
Ramakanta Sobhapandit.
Ramakanta Sabhavati is my father and his the brother's father. The plaintiff's father-in-law.
Ah.
Both are brother and sister, my lord. Nonikanto and
Hmm.
Nonikanto and my lord, this Oditi.
So,
So my lord,
so your cases goes.
uh,
Now enough. I think we dictate now.
my lord, some more point is there.
Huh?
More discussion is
There's
necessary.
no discussion.
My lord,
Hey,
they failed, my lord. They had admitted that since 1985 they are not in position. They left the place.
Mr. Deka, where is the necessity that a person requires to be in possession for having title?
Because my lord, he purchased the Angul land on Angul land, my lord. Angul land which purchased by some purchaser. But the auction.
Your suit was the defendant did not have title over the suit land. That suit was dismissed.
Defendant was not title, my lord. By way of the purchase, my lord.
Yes. Defendant had lost all the title over the suit land by way of purchase. That suit was dismissed.
My lord, he purchased from one Upali, who they auction purchaser in 76 minutes. But they never took possession. 676 is not position.
Whether they have taken possession or not, that is not the question. The court did not come to an opinion that you are adversely possessing. An adverse possession is a mixed question of law and fact.
My lord, they have stated that we have permissive occupier. Permissive occupation joint, my lord. They have stated that since 1974 they are constructing a house in our father's land. And so I am a permissive occupier, my lord. But at that relevant time, they are not the owner, my lord, because they have purchased subsequently, my lord, 1989, as per their pleading. So at that relevant time, the auction purchaser is the owner, my lord. He never took position, my lord. After auction purchase, he never took position. Since 76. In 89.
Man not taking a possession does not make that he has lost the possession. You are to prove that you are in adverse possession.
Same document, my lord, because he is the uncle land, he is purchased, my lord. Although he started that he.
No, have you shown anywhere? Let us see the trial court judgment in the first. Trial court was in your favor or against you?
No, against me.
All.
Yes.
Good,
But
good.
my lord,
Very good.
but my lord, it was,
Sometimes easier for me.
my lord, in it's two. The same land is, my lord.
So here it will be, the cost will be 11,000, 11,000, 22,000 then.
Interestingly, interestingly, my lord, original no, na.
You are paying for somebody.
For the defendant, but the response.
Okay.
My lord, original plaintiff died, my lord. So her sister come in the as a plaintiff, my lord, appellant.
Let us see where is it. Where is the judgment of the trial court?
My lord,
It is 8 to 24, brother.
Page
8 to 24.
page
8 to 24. Oh.
My lord, originally the land was 4 brothers.
Whether right plaintiff has right title, whether Iman, where's the counterclaim? In course of the defendant here. Where's the issue for counterclaim?
No, my.
Huh?
That is also one of the substantive question of law, my lord.
That can be a substantial question of law. Where's the counterclaim? Suit is for the plaintiff failed and the counterclaim of the defendant is decreed. To what relief the plaintiffs are entitled to? I've gone through the Iman materials on here, the law of adverse possession from Article 65. The date from which the lien
there is a one after that point. Subsequent question is formulated. There is no.
Okay. What are your documents? Exhibited documents? Did you exhibit any document? No. Oral?
No. That is document.
Nothing. What did the plaintiff exhibit? Defendant exhibit? Plaintiff exhibit? Nothing.
Defendant exhibit, my lord, that
Exhibit document. Okay, let me come back at 2. Then I'll take that matter. Where is that lady gone? Yes. Record. Photo. Okay. The file 82. When was the suit filed?
2005.
2005.
What's the name of the plaintiff?
ODT Forma. He is no more.
Aruna Chakraborty.
It's the defendant,
Defendant is the daughter of her brother.
wife of the brother.
No, Oruna.
Wife of the,
Orna is the wife of the brother.
Yes.
Nani Chakraborty.
wife of the brother.
Yes.
Aruna. Nani Chakraborty, after that, Aruna's name has come in.
Yes.
Noni is the Noni to
Nani purchased it from
Sankumar Bhopal.
Kumar Bhopal. Who purchased from auction purchase?
Auction purchase.
And why is the name of Noni in anything to do with the Jorhat municipality?
But he actually is the son of the, my lord, his son, my lord. So he, instead of his father, he made a decision
In
in a municipal
means in respect to the holding.
holding
Holding is in his name.
in his.
Okay. Is there any holding in your name?
Earlier, there
There is no holding. No evidence to that effect.
no way. Because the land is adjacent. My lord. Father's land and uncle's land is adjacent. In this case, regarding the uncle's land. My lord.
So the suit land initially was the total land was 1 biga 2 katha 11 lechas, of which it was partitioned,
Not forwarded.
and on 1970 PP number 298 was partitioned between the pattadas and separate patta number 391 in the name of Harikanta Sharma Somapandit, 392 in the name of Gorikanta Somapandit, and 393 of Horendranath Somapandit. Now, all three belongs to Ramakanta Somapandit's something.
Brother.
Son.
All are brother. All are brother.
Brothers of
All four
Son.
brothers. Ramakanto, Goriganto, and Horendo. All are brothers.
okay.
So the
Now we are concerned with patta number which one?
391.
391. This is the
391 stood in the name of Harikanta Somapandit.
Yes, ma'am.
Okay. Now you did not challenge the patta.
No.
How did you acquire your title on the basis of that?
No, my lord. Originally, the inherited property of four brothers. The separate patta of the equal share has been given, my lord. And my father part is the eastern part.
Understood. Your father's patta was which one?
My lord, the original patta 291. It is remained as the
298.
298.
298 was your father's.
Yes.
Ramakanta.
Yes.
Yeah. So that remained.
That remained.
You are still in possession with that.
Yes, ma'am.
Okay. So that is okay. Now 391 belongs to Harikanta Somapandit.
This now come from my lord 298.
Maybe,
Yes.
but it has come out
Yes, ma'am.
in 1970.
Yes.
You have not challenged it.
Not sure.
Okay. Now this 391 was put to auction sale.
Auction sale before that, Goriganto was not possessing the land, although in his
Forget about that.
Yes,
I am not concerned.
Yes.
391 was put to auction sale.
Yes, ma'am.
391.
Yes.
Where you had no title.
No right.
391, after it was fell into the layer of that land, You are claiming adverse possession. Who was claiming adverse possession in 391?
The daughter of Roma Ganpamet.
How?
He is the unmarried.
What was the age at that point of time? 1970?
He is no longer now my thought.
No. What was the age at that
Yes,
point?
Major, sir. Date, age is not here, but she was major because she was living with him father adjacent land, and along with his father and mother, he remained with them. So during that period, father extended their residential area to that block also because Horiganta was not here. And to that effect, my lord. That is
So
why-
did you challenge the auction sale?
No, we did not. We have not received any notice. Nothing has been.
Anyways, you did not challenge. So it went to auction sale.
Auction sale is
Once it went to auction sale,
yes,
auction sale happened when?
1976.
1976.
76.
Okay. What was the age at the year 1976? You filed the suit when?
2005.
2005. I'm
What was your age shown in your claim? You have 48 years in 2005, which means it would have been another 25 years, 23 years. 23 years. Okay. You are unmarried.
unmade.
Okay.
My lord, one point is there.
So it went into auction sale.
Yes.
Once it goes into auction sale, the government has taken over the property.
No,
That's the law.
my lord, actually government first declaration of made a auction sale, my lord. Then after 60 days, it is confirmed, my lord.
Understood.
He will took the position, my lord.
Understood. But whenever the government puts on auction sale, the possession has been taken over by the government.
My lord, first notice will go. Then if we
That's
pay
it.
money,
That is a different thing. Whether notice, you have not challenged this auction sale.
I am not selling, my lord.
So under such circumstances, that aspect as regards the auction sale, once the auction sale has been taken, the possession has been taken over.
After sale, my lord. Yes, it is
That is by deemed.
theoretically it is.
It is deemed.
Yes.
Once the possession is taken, so your break is there already.
Break is there, my lord.
Okay. Now tell me, where is your statement after 1976? It was sold to Suitland fell in the sale for default in revenue, and one Bhopalia purchased the land in the above referred lane, and his name was recorded in the record of rights, and accordingly, the said heir in his turn sold away the heir to Nonikanto Iman, and his name was mutated in 1989.
Yes.
Okay.
89, my lord.
In 1989, his name was mutated.
Yes.
Did you challenge his mutation?
No, my lord. I have not challenged, my lord.
Understood. What overt act did you do to show that you were in any way you were possessing adversely to the true owner?
My lord, firstly, I am possessing here. They have no possession. But
No, possession,
So,
Mr. Deka, I think you understand what is the law of adverse possession. I also understand what is the law of adverse possession. So don't make this submission before this court to the effect that you are possessing. Long length of possession is not adverse possession unless you show an overt act. What have you done? There is not a single document. All your documents are of 2004-5, which you have placed before the court.
Lord,
Exhibited documents. Nothing.
overt, my lord, when they came to possession, my lord, in 2005.
I myself, during the lifetime of my father, possessing the Suitland through my father, on or from Iman, and the date of partition, and after his death, I have been occupying and possessing the land openly, adversely, initially against so and so. Right? This can't be adversely. What have you done openly? What do you mean by openly, adversely? Adversely has to be an overt act. What have you done? Nothing is there.
Openly means, my lord, he is nearer. He is my brother, my lord. He knows that I am possessing. He never claimed, in spite of the fact that.
Understood. He may not claim.
Yes,
Okay,
my
my sister is there out there. It's a
No,
case of permissive possession.
There is a evidence, my lord. There is a rift between the family. Rift between, so he has.
Where is that?
Yes, there are.
Where have you mentioned there is a rift between the family?
Yes, my lord, in evidence it is there,
Ah.
my lord. And they have
That my
admitted-
brother, Noni Chakraborty, in the year 1985, also due to some family dispute, shifted to another house and lived separately since then and never in possession of his ancestral land or the suit land at any point of time. Then
that is the only
that
evidence,
is
my
the
lord.
only
Because my lord,
that can't be
sir,
the
evidence is there because he married intercaste marriage is there. Therefore, my lord, there is family dispute. That is it. Other two will was executed by the father and mother, my lord, against him.
Now both the courts hold that you don't have adverse possession.
Yes,
I think it is enough to dictate.
my lord, regarding adverse position, I have no case, but my lord, their case for declaration of right title interest, my lord,
Declaration is you are admitting it.
I am
They are the owner.
but that issue was not framed on that point, my lord, because it is substantial right.
What is that? Substantial right.
Yes, my lord, they are the right title interest, declaration of their right title interest and recovery position, my lord.
Recovery of possession, it is categorically given out there that they are whether what reliefs they are entitled to. The courts have decided this. Hello. And the best part is this. You ask the court to frame 5 issues or 5 substantial question of law. The instant appeal. So the cost is 22,000. The instant appeal is filed under section 100 of the Code of Civil Procedure, for short the code, challenging the judgment and decree dated 17/6/2009, passed in title appeal number 21/07 by the learned district judge Jorhat, whereby the judgment and decree dated 26/6/2007
Yes, 26/6/2007.
2007 passed in title suit number 42/05 by the learned civil judge Jorhat was affirmed. আগতে য'ত district judge বুলি লিখিলো নহয় তাতে for short the first appellate court আৰু এই civil judge যে লিখিলো তাত for short the trial court, learned trial. The instant appeal was admitted by this court by formulating 5 substantial questions of law, which reads as under. The question whether the 5 substantial questions of law so formulated by this court are involved in the instant appeal. This court finds it relevant to take note of the brief facts leading to the filing of the instant appeal. The appellant herein, as plaintiff, had filed a suit being title suit number 42/05 before the court of the civil judge, senior division at Jorhat, seeking declaration and for permanent injunction.
Lord, one clarification. Present appeal in the name, I think OTT Sharma is there. She was substituted by her sister, madam. Originally she was performative.
One Ramakanta Sharma Somabandi. A plot of land measuring 1 bigha 2 katha 11 lectures covered by periodic patta number 298, admittedly belong to Ramakanta Sharma Somabandi, Horikanta Sobapandi, Horikanta Sharma Sobapandi, and Horendranath Sharma Somabandi. This periodic patta was partitioned by the Deputy Commissioner by its order dated 1970, whereby the land falling in periodic patta number 298 fell into the share of Ramakanta Sobapandit, the separate pattas being patta number 391 fell into the share of Horikanta Sharma Sobapandit, the patta number 392 fell into the share of Gorikanta Sharma Sobapandit. Agote Korikanta will ligito ha Gorikanta ha Korota Gorikanta. And patta number 393 fell into the share of Horendranath Sharma Sobapandit. Each patta had 1 katha 17 by 1/4 lectures. The plaintiff claimed to be in possession of the share of Horikanta Sharma Sobapandit, which is the separate patta number 391. On account of non-payment of revenue, the said land in patta number 391 was put to auction sale in the year 1976 in relation to case number 1759 of 1975-76. And one Santa Kumar Bhupal, BHUPAL, purchased the said land from the government. Subsequent thereto, the said Santa Kumar Bhupal sold the land to one Noni Kumar Chakraborty, sometime in the year 1989, and his name was duly mutated in the revenue records. The same Noni Kumar Chakraborty, as claimed by the plaintiff, was her brother, elder brother, cousin brother,
Elder brother.
own brother,
Yes.
was a brother. And due to some family dispute, he shifted to another house and did not remain in possession of the ancestral land or the suit land at any point of time. Pursuant to the death of
Yes, she passed away.
death of Noni Kumar Chakraborty,
1990.
the defendant number one, Srimati Aruna Chakraborty, she's alive.
She's alive. And the daughter.
Who is
Aruna is the
how
wife.
is connected to Noni wife?
Aruna is the wife and
Okay.
Antara is the daughter.
Yeah. After the death of Noni Kumar Chakraborty, his wife, the defendant number one, Srimati Aruna Chakraborty, got her name recorded in the record of rights in the year 1992. It was alleged in the plaint that the said mutation was carried out by the defendant number one mischievously and concealing the material facts. It was also alleged that in the year 2004, the defendant number one made a vain attempt to take over the possession of the suit land and thereupon filed an application before the Circle Officer East Circle, Jorhat, for demarcation of the suit land on the strength of the alleged mutation over the suit patta, but could not be successful. It is on the basis of that it was also alleged that the defendant number one collected building materials for raising boundary wall on the suit land, which was objected to by the plaintiff on 7/6/2005. It is under such circumstances the suit was filed, seeking declaration that the defendant had no title over the suit land, semicolon. Plaintiff acquired title over the suit land, semicolon. Permanent injunction be granted restraining the defendant, their men, agents from disturbing the peaceful possession of the plaintiff over the suit land, etc. Pursuant to the filing of the suit, the defendant filed a written statement cum counterclaim. In the said written statement cum counterclaim, it was mentioned that late Horikanta Sharma came in possession of patta number 391 after partition. The said land was put to auction sale for default in payment of government revenue, and one son Kumar Bhopal purchased the same, and late Nani Kumar Chakraborty, son of late Ramakanta Samapandi, had purchased the said land from the said son Kumar Bhopal by the registered deed of sale number 2777. So many numbers. Can't be so much. In 1984, so much of documents can't be.
27,007.
Intercept. 2777, dated 24/1/1984, and came in possession thereof, and got his name mutated in the record of rights by order dated 18/9/89 of SDC Jorhat, Pusto. It was also mentioned that late Noni Kumar Chakraborty was the only son of late Ramakanta Sabapandit, and he used to pay the land revenue of the said purchased land and also the other land of his father. It was also mentioned that the defendant, after his death, have been paying the land revenue of the said land along with other lands. Further to that, it was also mentioned that late Noni Kumar Chakraborty also constructed a house of the over the land covered by periodic patta number 298 of his father in the year 1974 partly, and in 1988 in the said land, and also in part of the land of periodic patta number 391 of his own. In addition to that, other constructions in the land of his father was also made by late Noni Kumar Chakraborty, and the construction formed one municipal holding. The municipal holding stood in the name of late Noni Kumar Chakraborty and bared holding number 389 of ward number 1 of Jorhat town. It was also mentioned that the municipal tax of the said holding had been paid by late Noni Kumar Chakraborty during his lifetime and after his death by his wife, that is the defendant number 1. In addition to that, the defendant further mentioned that the plaintiff is an unmarried daughter of late Ramakanta Sharma Sabapandi and used to reside with her parents. The plaintiff was only a permissive occupier. But in addition to that, the performer defendant number 3 was married to Sri Dulen Borthakur and she was residing with her husband in a husband's house situated nearby. And she was never in possession of the suit land. It was also stated in the written statement that the mutations were made in favor of Sant Kumar Bhopal and thereupon in favor of late Nani Kumar Chakraborty on the basis of purchase and possession. In paragraph number 7 of the written statement, it was categorically stated that the plaintiff, being an unmarried sister of the husband, and as a member of the same family, she was allowed to reside in the part of the aforesaid municipal holding. It was also mentioned that the defendant number 1, after the death of late Ramakanta Sharma and his wife in 1995 and 1996 respectively, allowed the plaintiff to continue possession as a permissive occupier only. And as such, her possession cannot be hostile and cannot mature into a title by alleged adverse possession. The defendant, in addition to that, on the basis of her right over the said land, suit land, sought for declaration, filed a counterclaim seeking declaration of her right, title, and interest, and for recovery of cast possession of the suit land by evicting the plaintiff therefrom. On the basis of the written statement filed by the defendants, number 1 and 2, come counterclaim, the plaintiff also filed a written statement to the counterclaim, denying the allegations, statements and allegations. On the basis of the said pleadings, the learned trial court framed as many as 4 issues. Of which issue number 2 pertained to as to whether the plaintiff had right, title, and interest over the suit land. And issue number 3 pertain to whether the plaintiff is entitled to the declaration of title and permanent injunction as prayed for. Although there was no specific issue framed as regards the counterclaim, but from the materials on record and the evidence so adduced, it appears that the parties were ad idem that the issue of right, title, and interest of the defendant and the recovery of possession as claimed in the counterclaim was also an issue. And as such, both the parties accordingly submitted the evidence in that regard. The record reveals that the plaintiff adduced the evidence of 5 witnesses and exhibited 6 documents. The defendant adduced the evidence of 3 witnesses and exhibited various documents. Amongst the documents which have been exhibited by the plaintiff, it is relevant to take note of that the exhibit 2, 3, 4, and 5 are documents which came into existence sometime in the year 2004-5, just before filing of the suit. Whereas exhibit number 1 and 6 relates to the certified copy of the Jamabandi. Exhibit number, on the other hand, the evidence, the exhibited documents of the defendants, where the certified copy of deed of sale, but whereby late Noni Kanto, na?
Noti Kumar Chakraborty.
Noni Kumar Chakraborty purchased the suit land in the year 1984. The Jamabandi of periodic Patta number 391, wherein late Noni Kumar Chakraborty's name was duly inserted, and thereupon the petitioner's name was also inserted. The land revenue receipts, which shows the name of late Noni Kumar Chakraborty, as well as the municipal receipts showing the name of late Noni Kumar Chakraborty in respect to the holdings standing over the suit land. The learned trial court, by the judgment and decree dated 26/6/2007, dismissed the suit and decreed the counterclaim in favor of the defendant. So, being aggrieved, an appeal was prepared by the defendant. Being aggrieved, only one appeal was prepared. An appeal was prepared by the defendant, by the plaintiff, which was registered and numbered as title appeal number 21/2007. Date to dismiss judgment and decree dated so and so. The said appeal was dismissed by the court of the district judge, by the learned first appellate court, by the judgment and decree dated 17/6/2009. Being aggrieved, the instant appeal has been preferred. Before further proceedings as to whether the substantial questions of law which have been framed, which have been formulated by this court by the order aforementioned, before proceedings on the adjudication of the substantial questions of law which have been formulated by this court by the order dated 2011-2009. This court had put a pointed query upon Mr. P.S. Dekar, the learned senior counsel appearing on behalf of the appellant, as to whether, against which judgment and decree the instant appeal has been filed, taking into account that the decree passed in the suit, the decree passed while dismissing the taking into account that by the judgment and decree passed by the learned trial court on
26/6/2007.
26/6/2007, there were two decrees which were passed. The first decree pertained to the dismissal of the suit, and the second decree was for decree whereby the counterclaim was decreed in favor of the defendants. The learned counsel appearing on behalf of the appellant, senior counsel appearing on behalf of the appellant, submitted that the instant appeal should be constricted within as regards as an appeal against the decree passed in the counterclaim. The consequential effect of the said submission made by the learned senior counsel appearing on behalf of the appellant is that the plaintiff's claim, the appellant's claim to any right, title, and interest over the suit land on the basis of adverse possession no longer exists, as the learned trial court as well as the first appellate court had categorically held that the plaintiff, the appellant herein, did not acquire any right on the basis of adverse possession. In view of the said aspect, The question therefore arises as to whether the defendants herein, the respondents herein, would be entitled to a decree by the learned trial, would be entitled to a decree for recovery of possession. Before further, this court further finds it also relevant to take note of. Also finds it apposite to take note of that the plaintiffs duly admitted that the defendant husband had purchased the suit land by a deed of sale. The plaintiff further admitted that the defendant's husband was the owner of the suit land. Therefore, the title of the defendant's husband, or for that matter, the defendant's, was not in dispute. The question therefore arises as to whether the plaintiff, without having any claim on the basis of adverse possession and having admitted the defendant's title, can forestall the right of the defendant to recover possession of the suit land. In that perspective, let this court now take note of the 5 substantial questions of law which have been formulated. The first substantial question of law pertains to whether the learned First Appellate Court had decided the said appeal by following the mandate of Order 41, Rule 31 of the Code. And whether the failure to formulate the points for decision in the appeal resulted in miscarriage of justice. This court have duly perused the said judgment passed by the learned First Appellate Court. And from a perusal of the said judgment, it reveals that the learned First Appellate Court have duly taken into considerations what is required to be done in terms with Order 41, Rule 31. It is further seen from the judgment of the First Appellate Court that the learned trial court, First Appellate Court, have duly taken note of the pleadings, the issues which were duly framed, the contentions which were raised by the counsels appearing on behalf of the parties, and given the decision and reasons for the reasons for the decisions. Full stop. Under such circumstances, the question does not arise. Under such circumstances, this court also did not find this. This court also finds it relevant to note that there has been no the learned counsel appearing on behalf of the appellant could not show as to how the non-framing of the point of determination had prejudiced the petitioner, the appellant. More so when the learned First Appellate Court have duly decided each and every issue as points of determination in the appeal. Under such circumstances, the first substantial question of law is not involved in the instant appeal. The second substantial question of law relates to as to whether the findings of the court below that the plaintiff appellant was in permissive possession of the suit land is based on no evidence. The said substantial question of law to formulate is not a substantial question of law involved in the instant appeal. Primarily on the ground that when the plaintiff claims that the plaintiff has been in adverse possession, and admittedly, when the plaintiff was a family member, it was for the plaintiff to show that the plaintiff's possession was adverse to the true owner. If such, however, from the materials on record and the findings which have attained finality, the plaintiff could not show that the possession of the plaintiff was adverse to the true owner. Under such circumstances, the conclusion so arrived at by the learned First Appellate Court, Trial Court as well as the learned First Appellate Court, that being a family member on the basis of the evidence, which on the basis of the pleadings as well as the evidence on record, cannot be said to be erroneous, and more so in the proceedings under Section 100 of the Code. The third substantial question of law as to whether both the courts below misconstrued the law and evidence relating to claim of the plaintiff / the appellant over the suit land by prescriptive right of adverse possession without taking relevant facts and materials on record is too vague a question of law. Too vague. Is not only too vague, but it is also a mixed question of law and facts. And as such, it cannot be a substantial question of law involved in the instant appeal. The fourth substantial question of law so formulated as to whether the courts below committed an error of law in declaring title of the suit land in favor of the defendant oblique respondent in the counterclaim arising out of in absence of positive evidence in support of their title. In the opinion of this court, is a totally misconceived substantial question of law, taking into account that the plaintiff had duly admitted the title of the defendants. Not only that, the defendants have also placed on record by Exhibit A, the deed of sale, by the various exhibits, that is the deed of sale, the mutation carried out, the revenue receipts, as well as the municipal receipts. And as such, the said substantial question of law so formulated cannot be a substantial question of law involved in the instant appeal. What is this section 27 of the Limitation Act?
The determination of the period.
Sometimes, Mr. Deka, I feel ashamed why the court, my predecessors out here have framed these type of questions of law. It becomes a laughing stock of the judge.
all are formulated.
And it is all your fault of making the court frame. You come up with these substantial questions of law. The fifth substantial question of law as to whether both the courts below committed an error of law in ignoring the provisions of Section 27 of the Limitation Act 1963 in absence of delivery of possession by the auction purchaser to the defendant oblique the respondents. In the opinion of this court, the said cannot be a substantial question of law involved in the instant appeal, in view of the fact that if Article 65, in view of the fact that in the present case, Article 65 of the Limitation Act 1963 is involved. For the purpose of application of the said article, the suit has to be filed based on title, which the plaintiff have duly done. The burden is upon the defendant or the plaintiff, which the defendant herein have done by filing a counterclaim. It was the burden of the plaintiff to show that the possession of her was adverse to the true owner for the prescriptive period of 12 years. Both the courts below have arrived at a finding of fact that there has been no case of adverse possession of the defendant, of the plaintiff. Under such circumstances, application of Section 27 of the Limitation Act is a totally misconceived notion. Accordingly, all the substantial questions of law which have been formulated by this court are not substantial questions of law involved in the instant appeal, for which, moving forward, this court now finds it very relevant to take note of as to whether the learned, moving forward, in view of the above discussion, and taking into account that the plaintiffs, the defendants have proved their right, title, and interest over the scheduled suit land, and the defendant and the plaintiff could not show that they have any semblance of any right over the suit land, the defendant is entitled to recovery of possession. Footstep. Accordingly, this court finds no reasons to interfere with the judgments and decree passed by the learned courts below. Full stop. Accordingly, full stop. Consequently, the instant appeal stands dismissed with cost quantified at rupees 20,000. The appellant, the defendant herein, the respondent herein would further be entitled to costs throughout the proceedings. Full stop. In addition to that, the LCRB. What are these? The other two test cases. What are these? These are not within my jurisdiction. These will be decided by those.
Who will Miller? Who will Miller?
Of whose?
Miller, between the same family Miller, one to the plaintiff and her sister.
Will of whose?
One is mother, that is Romaganto, and another is their mother.
Oh, how are these relevant? We are only with 391 here.
Regarding that plot of land maker, father given a will make this plot.
How can he give?
That is by virtue of this judgment, my lord, it is.
Father cannot give.
Yes.
And apart from that, if you anyway, let this as this court is presently not taking up the roster of of first appeals. The matters be listed. The matters are segregated from the regular second appeal to be listed before the appeal.
Additionally, the will alleged by my learned senior colleague to have been given by the father of the appellant here, that will does not find place in the record. It is with the head assistant. Only the copy. It is with the head.
Madam, I had great difficulty in convincing the registry to detag me from all these regular first appeals. And therefore, this first appeal should go, you have now a bench.
Yes.
Court number 14, go there.
Applied.
Yes, madam, where is that, madam? Yes, what is your case? Let me come back in 5 minutes. Much of it. Davis matters, one needs to think so much. Not so.
So on which day, your lord?
Are you saying that the submissions of Mr. B.D. Decker requires to be taken up for such serious thing in that matter that one has to make it serious? If you consider it, then I may think about it. That it is a very good submission. In my opinion, 65 and 66, which he have made, he said 66 and 68, 67, 65 and 67. One is for foreclosure, and the other is for 65 is for adverse possession. Adverse possession in respect to Schedule B and Schedule A is foreclosure. Do you think that such submissions are worth to make it savvy?
So the matter will be heard once again, your lord.
No. Why do you need? I was supposed to only pass the judgment, but the matter came up so down in the list. I asked them to put it on the top of the list.
So next step will be fix your lordship according to your lordship, convenience your lordship. But in the upper side, your lord. In the upper side, your lord.
Yes. List I put it out there. It will list it on top.
Specific order may be passed, your lordship.
Order. I did. Earlier I have given it, I thought this matter will come up at the top of the list. Anyway, list this matter on when? Fourth at the top of the list.
So if it is not listed that way, your lordship, may I take the lordship permission to mention it, your lordship, on that?
The top of the list I've said.
Four.
Last time I didn't say that. Earlier it was said. Fourth. Yes, madam. What is your matter?
May I, your lordship?
Mm.
In 1948, I'm just briefing the fact. In 1948, 4% jointly took settlement of some kind. The two plans jointly have taken settlement as per document. That was on perpetual lease. Settlement was the mode of perpetual. Thereafter, exactly what happened, no picture, but except A, B, and C, D, I'm for B, I'm the defendant. Only B, still date, is in possession. My client is in possession. A, C, and D never took possession. The picture. Now, in 1952, A, the plaintiff, he executed a relinquished deed. Relinquished his total share got the land. Up to that, it is okay.
In your favor.
Yes. It was registered deed. Next C and D, they also never came for taking possession. Now, suddenly, in 2007, this continuous possession without any interaction. In 2007, that A, whose predecessor executed that relinquished deed, he filed a suit for right title declaration over the suit. This is short. And now, the courts below, they have ignored the registered. And this is the main issue here. Exhibit B. Exhibit B. Relinquished. The learned court's findings on that, though it was registered, but the registered
Who is the plaintiff?
Mr. Dekar is for that.
Mala Chaudhary.
Yes.
Arun Chaudhary. Ornali Chaudhary. You are Debabrata Chaudhary.
Yes.
And who is Vikas Chaudhary?
And they are the other co-owner, you may say.
4 to 13. 4 to 13.
Kotian, Kacha Patta, Final Patta. Everything
Yes, tell me.
Me, Your Lordship.
How does issue number 6 is being taken by the trial court?
Forty.
Issue number 6,
44.
5 and 6. What is the opinion?
Your Lordship, regarding registered deed of release,
Hmm.
the learned word of opinion is that the registrar has himself identified the executor.
Hmm?
The registrar has himself identified that that person is known to me. This endorsement was there, which is according to learned course group, which is illegal, which can't. According to them, the third party should be there to identify the executor. But this is wrong conception, Your Lordship. As per section
Where? Now, how does the trial court deal with issue number 6? Because we have main concern with issue number 6.
yes, Your Lordship.
How does the trial court deal with issue number 6?
This is the finding as because the registrar himself has identified the executor, so it is invalid. This is fraud, according to them.
Show me that finding.
Yes. Yes, Your Lordship. The page 47, Your Lordship.
Hmm. Yes.
Page 47, the middle part. Paragraph 13. Paragraph 13, starting. Dependent number 1, may I read out?
That deed was executed in 4/3/1952.
Yes.
And Kiran Kumar Chaudhary was the executor.
Yes.
And he died in 1950.
The same year. No, Your Lordship, actually that was typographical mistake. In another proceeding, it's 145 proceeding, there was some typographical mistake. In place of 1952, it was by mistake in written 1950. That was later on corrected. But this is just a
No, whether the sale, what you call the death certificate was exhibited.
no, Your Lordship, actually he is not directly my client's. That death certificate is submitted by them, the plaintiff side.
No, has the plaintiff submitted?
No.
Yes, Mr. Detta.
Lord, in fact, we had exhibited some Shraddha ceremonies document, and as per their own admission, in the course of the 145 proceeding, Lord, they had said that 1950 Kiran Chaudhary had died. Now, taking these two into account, the court held that the execution was not proven, more so because there was no witness. Both the page 47, if your lordship takes up, 47 and 48.
Was it true that this Kamini Kumar Chaudhary was a resident of East Pakistan?
From oral evidence, it was gathered. Both the courts have held so. And therefore, they also drew the inference that how could the sub-registrar know someone who hails from Haldia or something. This is essentially a question of fact, but both the courts have concurrently held that since Exhibit 13 is very clear, the year of death is specifically mentioned by them as 1950.
But that has been held to be a weak evidence by the trial. Exhibit Q and Q1 has been held to be a weak evidence by the trial.
My lord, Exhibit M, perhaps.
Exhibit
Because
Q and Q1. Page 47.
Yes.
A weak evidence.
Well, Q1, of course, Q and Q1, but your lordship sees the discussion on Exhibit 13 at page 48.
Now that I've seen it.
Right.
So you left Kamini Kumar Chaudhary left for
East Pakistan.
huh? How did you come back?
His son, my lord, Bhaskar Chaudhary, was employed here and he used to stay there. And in fact, there are categorical findings on possession of. And our case was that the defendant himself was the sub-registrar.
Huh?
He was also a sub-registrar, the defendant. So that is why we say that they have manipulated and that is how they got it registered. And in that registered release, there's no one identifying the executant but the sub-registrar himself.
But the deed must be there.
The deed is there.
So the deed will show who is the defendant, who is the registering authority.
Yes, my lord, that those witnesses were never called.
No, the registering authority will be the name if he is the defendant.
No. He himself did not register, but there's an endorsement that the sub-registrar knows him personally. Therefore, there was no identifier.
So is it required to be identified?
Well, of course, there's section 34 which says that if he's personally known, then perhaps he can register or not. But now, ultimately, what the courts have basically done is they have held that the presumption under 70 is rebutted because of the fact that they could not prove that by their own admission the executant allegedly had died prior to execution. There was no identifying witness. And further, we had also led evidence to the effect that he died prior. Though Q1, Q2, again, my lord, the appellate court has also dealt with that issue at page 80, my lord. Para 23. Para 23, page 8.
Bhaskar Chaudhary is the son of Kiran Chaudhary.
Yes.
And who executed the release deed?
Kiran Chaudhary.
Kiran Chaudhary, in fact, his son, the executant son.
Kamini Chaudhary was the sub registrar, my pet. He was the sub registrar and Kiran Chandra Chaudhary was the Muhuri at the advocate's clerk.
Your client is Devabrata Chaudhary.
He's son of Kamini Chaudhary.
Successor.
I'll just explain the background, my lord. There were 4 persons who had got this land on lease. 2 of them brothers, 2 of them cousins. Now, Kamini Chaudhary, though everyone's name figure in the deed of that
Cousins means same father.
Own father.
Own father, but mothers are different.
No.
No, my lord. Kamini and Kiran are own brothers, my lord. Indu and Vinod Bihari are cousins.
How? Means they related someone.
Related to some. Now, Kamini Chaudhary says, my lord, though the registered instrument has all the 4 names, Kamini Chaudhary in his written statement takes up a plea that it is only out of sympathy that I entered the other 3's name. Now, thereafter, he again says that 1952, Kiran actually executed a release deed in my favor. Now, that release deed was challenged by us, saying that that's a fraudulent document. You were yourself a sub-registrar. In fact, he was he had hailed from the Sylhet, East Pakistan and Bangladesh, and he never came to sign. Now, in a parallel 145 procedure,
Does the defendant admit that he was in East Pakistan?
yes. That is how they want to say that we were never in possession because my father was always in East Pakistan.
But how does he say about paragraph number 20 of the appellate court judgment?
No. Yes, but 20.
Paragraph 20.
20. My lord, basically, what they try to say is that these names were just entered on the ground of sympathy. Kiran Chaudhary was never in possession. He was always in Bangladesh. The answer to that was that no, Kiran Chaudhary could have been in Bangladesh, but his son Bhaskar Chaudhary was enjoying possession of their land.
But this was admitted.
Yes.
Paragraph 20.
Yes, and they admit ultimately. That is
Being
why
a relative, anyone can stay with anywhere. It's a very common thing.
Then,
my lord, in the course of cross-examination, they admit that Bhaskar Chaudhary used to reside here because he was employed at Karimganj. Now, taking all of this in perspective, my lord, first of all, the court holds that I have joint possession since Bhaskar Chaudhary was residing in that particular property. Number 2, it holds that that explanation which was given that only for sympathy it was entered, that was discarded. And thirdly, it holds that the release deed is also invalid. And secondly, the others have never executed a release deed, the other 2.
where were the others? Let us not consider about others. It is your father who has done it.
Yes.
If the plaintiff numbers 1, 2, and 3 are from Kiran Chaudhary.
Yes.
Kiran Chaudhary.
Yes.
So if Kiran Chaudhary's release deed is in favor of the defendant, then in that case,
they'll have to fight it out.
the
with
others we are not concerned because they are not parties. They are not the plaintiffs. They have not approached. They're not concerned. So the question is whether that the release deed was there in favor of the plaintiff was the property. Now, section 34, how are you saying that he cannot, that the sub-register could not have come to know about this person or recognize him?
My lord, my lord, the courts have.
Let's see section 34. Please.
34(3)(b) says, Lord, he must satisfy himself as to the identity. And 35 says, if they are personally known to him, or if they are otherwise, if he's otherwise satisfied.
Come to on judgment. But But madam, whatever questions of law you have framed is
These are facts.
hopelessly wrong. This is not the questions of law which just because unless you get hold of that, release it in your favor, others becomes inconsequential.
Yes, Your Honor.
Others becomes inconsequential because otherwise you fall in the trap of 110 of the Article 110. So they have never at any point of time been shown that okay, you have no right over this land. So their main document is the release. So your question of law should have been whether a person concerned, whether the release deed was executed properly or not, whether can you say it to be fraudulent or not, whether because they have not proved the death.
Yes.
Proof of death has to be on the basis of a death certificate. They have not proved that. So the only question was on 34. And what type of questions of law you have framed?
Your Lordship, actually, substantial question for the second one, whether a legally executed and registered deed could be held as fraudulent, collusive, void, or inoperative on the basis of contradictory statements as to the alleged death of the executed prior to making of the document.
Well, let's see section 34. What does it say? So
I mean, read.
Yes.
Subject to the provisions contained in this part and in section 41, 43, 45, 69, 75, 77, 88, and 89, no document shall be registered under this act unless the person executing such document or the representatives assigned or agent authorized as aforesaid appear before the registering officer within the time allowed for presentation under section 23, 24, 25, and 26, provided that if owing to necessity or unavoidable accident, all such persons do not so appear, the registrar, in case where the delay in appearing does not exceed 4 months, may direct on payment of a fine not exceeding 10 times the amount of the proper registration fee. In addition to the fine, if any, payable under section 25, the document may be registered. Appearances under subsection 1 may be simultaneous or at different times. The registering officer shall thereupon A. Inquire whether or not such document was executed by the person by whom it purports to have been executed. B. Satisfy himself as to the identity of the persons appearing before him and alleging that they have executed the document. And C. In the case of any person appearing as representative, assigned, or agent, satisfy himself of the right of such persons so to appear. Any application for a direction under subsection proviso to subsection 1 may be lodged with the sub-registrar, who shall forthwith forward it to the registrar to whom he is subordinate.
So 3B,
3B.
satisfy as to the identity of the person appearing before him and alleging that they have executed the document.
Yes.
So can't the register say that I'm satisfied, I know him?
He can, my lord.
Then?
He can under 35. Under 35, if he is personally known to him, he can do
34 3B.
3B and 35. That he can, my lord. That is not the.
Then?
My lord, given the totality of the circumstances, the courts have held it a finding of fact that this presumption stands rebutted because of two reasons. Number one, that they themselves admitted 1950, my lord. I led oral evidence to that effect that my father died in 1950. That was corroborated by their statement in the 145 proceeding that he indeed died in 1950. And lastly, the courts also hold that he cannot be personally known because he is.
Where did your father die?
He's Pakistan.
He never came to India.
He never came to India. That is my case, my lord. And in fact, they've also said. I mean, they also contend that he went away to Bangladesh, my lord. That they contend to show that we did not have possession. So that my father was there in Bangladesh.
Let's see the defendant. Where does he say that he has gone to the Bangladesh? In his written statement, he must have said that.
In his written statement, well, this.
If he have not stated that, then how can he say that?
Who's not?
Has a written statement, has he stated?
My lord will see the written statement first at page 34, my lord. Just to mislead this honorable court in order to deprive the answering principal defendant number one of his lawful property, taking advantage of him being poor, old, ill-fated father of a 28-year-old mentally retarded only son, out of emotion and sentiment and being regulated by sympathy for his younger brother, Kiran Chandra Chaudhary, and Kiran Chandra Chaudhary's sister-in-laws, Binod Bihari Talukdar and Binod Bihari Talukdar's cousin, Indu Bhushan Talukdar, who were residents of Sylhet district of East Pakistan, said Kamini Chaudhary, father of the principal defendant number one, inserted the names of Binod Bihari Indu Bhushan and Kiran Chaudhary in the above registered deed number so and so, so and so, so and so. Now, my lord, on the following page, my lord, at page 35,
Where he has stayed in East Pakistan?
page 34. Page 34, para S.
Plaintiff intentionally suppressed the fact just to mislead his court in order to deprive the answering defendant of the of him being poor. Plaintiff is alive. Defendant number one is alive.
Yes.
How old is he?
90 years. 90 years.
And how many sons and daughters he has?
One son is mentally handicapped and one daughter. She's married.
No, it does not say that they were in East Pakistan at that point of time. They did not come.
They did not.
Then also his name was inserted in 1948.
Yes.
So that is, has been mentioned because 1948, the deed happened in 1948.
42. No,
No, not this deed, the earlier one.
48.
40.
Your lordship, the very difference in examination chief PW1, the plaintiff number 2, his category admitted that after taking tenure holdership in respect of the two plans, Kamini Kumar Chaudhary, my client, first came to India along with his nephew Bhaskar Chaudhary.
Your client's father.
Yes, the client's brother. That is my father, and followed by them, State Kiran Chandra Chaudhary and his other family members also came to India.
When?
Time is not written. Year has not been mentioned.
PW2.
PW2.
Who is the?
Borun Chaudhary.
Who is the son?
Son.
So he admits that he came.
Of Kiran Chaudhary. Grandson of Kiran.
Grandson of Kiran Chaudhary.
Present plan.
He came to India.
Though there is no specific evidence about it, but during a short period of time, Kiran Chandra Chaudhary was working there in the Karimganj court as a local language called Muhuri advocate for a short time. In this connection, everyone knows him as Kamini Kumar Chaudhary was.
Did they amend the plain?
Yes, one time they have amended. Yes.
That challenging this deed.
Not exactly that.
Let's see. Amend the plain. If
I'm
they have
sorry,
not
I'm
done
sorry.
so, if they, this is the plain, have they challenged the deed? They only say that if any deed has been done in the meantime, so they must have known about this deed.
They have said in their evidence that they only came to know after defendant number 1 filed the written statement. And thereafter, probably they have filed the amendment.
And the defendant numbers one's name was after the release deed was inserted in the mutation records.
Yes, you're
all
right.
along.
You're right. Patian, Kacha Patta, 2 times.
Alone.
Final Patta.
Alone.
Alone. And the one surprising thing is there, your lordship. My client submitted a Khatian where the only name of Kamini Kumar Chaudhary is there. They also submitted the same Khatian issued on the same day. But there is written Kamini Kumar Chaudhary and Gong. Gong in the Karimganj language and others. Kamini Kumar Chaudhary and others. That means the other 3 persons were ill-coded according to their submission. But father was the only Kamini Kumar Chaudhary's father. This can't be. And the second one is that any land record, they always used to mention the specifically the name, not others. And your lordship can see that evidence exhibit 11, your lordship, overwriting is there. That was manipulated, that was false.
Now, if they have not challenged the says deed,
yes,
how can they lead evidence to that effect that he is dead or something? It's the plaintiff who has to do. How can they lead evidence as regards he died in 1950 and whatever and all? You have not stated anything. Without pleading, there cannot be any evidence. How can this trial court or the first appellate court look into all these things without there being pleadings?
they have taken to
Have they mentioned at any point of time that the Kamini Kumar Chaudhary or what is that Kiran Chaudhary never came to India in their plane?
Well, plane had probably I checked up because the plain annexed the appeal memo appears to be an unamended plain. But I remember coming through. I'll just check.
Original. This is the unamended plain.
No. Amended plate, your lordship. I have annexed it as amended plate. Amended plate, amended.
Is a counterclaim also filed?
That was Ujjan.
Huh? Huh?
That was Ujjan.
You filed a
Subsequent-
counterclaim.
No, Your Lordship, the other defendant. Defendant number 2 to 11.
They withdrawn.
They have withdrawn.
So this counterclaim which they have filed, counterclaim submitted by defendant number 2 to 11. When was it withdrawn? Yes, others. Yes, Mr. CKS. Did you get anything? Did you file your affidavit?
No, we have not filed it. Lordship, I have communicated and Lordship, they have reverted me and they have forwarded one email.
Ah.
Secondly, Lordship, the affidavits also I have sent to the Bharti Airtel. They are investigating into the matter, Lordship.
Hmm.
So they are seeking some time, Lordship.
How much time?
As per this letter, Lordship, 4 weeks time, Lordship, I will show you. The email I have from the department.
Because their statement is very required. You file an affidavit.
If they're into it, Lordship, we'll get it raised.
Okay. Itu item number
12, Lordship.
12. Na? Okay. Mr. CKS Borua, the learned CGC, submits that pursuant to the order passed by this court on, do you have a date?
Date?
On dated 20
12, 324. 12/3/24.
12/3/2024. The matter has been duly placed before the Department of Telecommunications, and he has received an email that a detailed investigation is being carried out by the Department of Telecommunications, and for which they have sought for 4 weeks to submit a comprehensive report along with the affidavit. So, taking into account the above, list the matter again on. Let's have it on. Can we have it on 13th of May? 4 weeks is good. On 13th of May, on which date the learned council shall ensure the affidavit is filed.
Lordship.
To ask them people to file the get that there, because he's after all a pensioner. We have to do something.
Once we receive, Lordship, I'll definitely
Yes.
file.
List the matter for further consideration. You inform Mr. Manan about it.
Yes, sir.
And the other, Mr. J. Roy and all the other. I don't. When was this counterclaim withdrawn? Because that is also very pertinent.
My lord finds that in the judgment of the appellate court.
No, it will be there in the record. No? This
2/11.
counterclaim was filed on 2007. 2007.
Yeah.
77.
Amendment application was allowed on 11/12/2008. See the amended. You don't see an amended plan. It was filed in 2007, nah?
August 2010.
Mr. You have only sought for a prayer, not the body of the plane. Then,
That was included as prayer 4.
then how can you raise all about 50 years? He died in 1950. Even in your statement out here, you have not mentioned.
I've led evidence to that effect.
How can you lead evidence that he was dead? Those evidence are to be totally disregarded. Not, there's not even a single statement in the plane. How can you lead all this evidence? You are saying all this fraudulent, but there's bereft of any pleading. Can you challenge the deed without the pleading? Talk. That is why you don't see the amended claim too much anywhere. What you are asking in the amended claim is this. See that? This is your appeal. How do you help yourself? This is the petition. It was allowed. And therefore you find the relief.
Issue number, the prayer number 4 was added.
And you just check out from the record out there. Do you find an amended claim? I didn't find any amended.
It was amended by hand.
This is what. Therefore, there is no material. How can you lead all this evidence? And madam, you have not raised a specific question.
Sorry, put the order.
You have not raised. That is your substantial question of law. As to whether the courts below were justified in taking into account all this evidence without there being any pleading. Not a single pleading is there that this person died in 1950. That this person was known to all these things. Nothing is there. And you have given 5 or 6 substantial questions of law to disturb this court. We do one thing. We frame a substantial question of law and give him an opportunity. Okay? We'll have it on some other day. Okay? Because there the problem arises, Mr. How can you lead all these things, the issues which have been decided, that issue could not have been decided in your case. And if that issue cannot be decided, that goes. Secondly, if that counterclaim has been withdrawn by the defendant number 2 to 11, their right over the land cannot be there. Can the court decree about 1/4 or anything about to them, other people?
I'll advance. I'll advance my submission once you're not.
Let's see the trial court judgment, what is given. Trial court has gone as if he is a plaintiff have been able to prove the issues as such, and I have reasonable finding that plaintiff is entitled. According to the land area, the suit is decreased on contest. If to conclude the plaintiff has a cause of action from the discussion in issue number 6, I have arrived that the plaintiff has been able to prove a case. What purposes from the so the plaintiff and the defendants have the right, title, and interest in landholder right over 1 acre of land within so and so and so to inheritance and in Ismaili, and that the registered deed of release dated is so and so. How can the decree be given on favor of the performer defendants when they withdrew the counterclaim?
Well, if it's concerning co-ownership rights.
So what?
If
They also claimed when they withdrew it without anything. They never asked for anything.
True, my lord, but if we apply the same understanding as in the case of partition suit.
Understood. You did not, but somebody has relinquished.
No, my lord. The relinquishment is only shown.
No. Kindly come to Order 23, Rule 1. It's abandonment of the claim. Once it is abandoned, how can there be a decree in favor of the performer defendants? How is it possible?
My lord, if my suit remains, and if the parties are at the litigative status since it's co-ownership, my lord, if we apply the same principle as in the case of a partition suit, that notwithstanding the litigative status of the parties, my lord, the court can declare the right.
No, but when they have
They have
withdrawn,
withdrawn, that's
they have abandoned the claim over their rights. And when they made a specific claim in respect to 1/4. So if they have abandoned their rights, how can the court decree the suit? And more particularly as regards that other half, you are only 1/4. 1/4 is the defendant number 1, and another half is of the performer. Now they have withdrawn. They abandoned the claim by withdrawing of the counterclaim. Can the court have granted the decree in their favor?
Well, to that extent, of course, subject to what my friend says. But
I'm not going to hear her only. She is not there. But court couldn't have given. Impossible. There is some principles of law, I suppose. Huh? And the court, you have only asked for that amendment. Look, Madam, these two I am framing, saying all the other questions of law are absolutely useless. Else I am not framing those.
I'm extremely sorry, Your Lordship.
Whether to decide the point of limitation in respect of filing of the suit for every cause of action issue is the duty of the court or a matter to be left by the court upon the parties to plead and press. Why? Question of limitation. What did the trial court say? That you did not press.
Yes, Your Lordship.
And the first appellate court went in on the same basis. These courts have not seen the language of section 3. How do you protect these type of orders?
Well, Section 3, of course, is there. But
Without even a defense being pleaded, it has to be, the court has to decide that. Anyways, upon hearing the learned counsels at length, this court is of the opinion that two additional substantial questions of law arises in the instant appeal. Number one, whether the learned courts below were justified in taking into account various evidence which were beyond the pleadings in coming to a finding as regards issue number 6.
Yes,
Number 2, whether the learned courts below were justified in decreeing the suit, thereby granting rights to the performer defendant, the defendants as well as the performer defendants, in spite of the defendants number 2 to 11 having filed the counterclaim and having abandoned their claim in terms with Order 23, Rule 1 of the Code of Civil Procedure 1908. Question mark. List the matter on when
Your Lordship, 1 week time.
1 week time I'm giving it to him. Otherwise, it looks bad to frame it today and dispose of. Otherwise, it is a fit case to be disposed of today itself. He may tomorrow take up that plea in the Supreme Court saying, look here, I was not given, it was only heard during the court.
can your lordship
That is the reason he is there on the other side. I have not struck off these substantial questions. You never know. One, I may have to take recourse to any of.
can your lordship have it any time after 23rd? My lord, can keep it as part of it.
This is the matter on 25th of April. And at the top of the list, showing it to be a part. Yes, any more matters? Mr. Sahevala, your matter. Hmm. I have intentionally not taken up those matters. Taking into account these are all bench 5 matters. Why should I take it up? Let it be done by the courts.
It may be after.
That's the matter, no? You are saying on that capital subsidy or capital subsidy. Because what happens there? I'm taking up second appeal, so old matters.
My lord, that's correct.
And today I've been only able to finish up 3 or 4. That's all.
5 matters.
Huh?
5 matters dispose of it. It's not 10 matters. But after long judgment is fixed.
Okay, when. Yes, you have filed your.
Yes,
Yes.
yes, we have filed.
Okay. Let's have it on after Bihu. Can we have it on 23rd?
My lord. Lordship, my item number 8.
Wait.
This is item number 9.
Item number 9, list the matter on 23rd, 23, 4/2024, at the top of the list, taking into account that the matter have been substantially heard. Yes,
Item number 8, your lordship, the FAO of
Oh,
2017.
that's, we'll finish it now.
Lordship.
We'll do it. FAO is too small a map.
Lordship, item number. He is for the appellant.
Yes, yes, we'll take it up. FAO. FAO is a small map.
Lordship.
Yes, 2017 FAO. What is it? Against?
Lordship, my temporary injunction fare was rejected.
Huh?
Temporary injunction fare was rejected.
Then what happened till now? What has happened to the suit? Suit decreed.
No, Lordship, I am appearing in this case only on, it was dismissed, appeal was dismissed. I am appeared in the miss case, restoration appeal. For some other was there.
Restoration.
Some
So
other
the
appeal was
injunction was paid, your lordship, in respect of a spark. So he is keeping the appellant, he kept the vehicle in the park. So that is why he filed this suit, your lordship, seeking an injunction against the
No, appeal has been restored.
appeal restored.
Okay, now tell me, what do you want? Okay. In the FAO.
Therefore, Lordship, the injunction, the interim injunction order at 156.
Now, what has happened to the suit? Suit is of 2016. We are in 2024.
Okay.
What is happening?
The suit was by some other advocate. I am not engaged in this suit.
Understood. What has happened to the suit?
Lordship, at the stage of evidence.
What was the injunction he sought for?
Lordship, he sought for the injunction.
What injunction?
Lordship.
Lordship, at the page.
Case of the plaintiff is substance is the owner of the so and so.
There are
Our
two
rival submissions and I went to the stalemate of the petitioner recital of
at
the
page
statement clearly
156.
spells out that in so many words that there is a common entrance measuring approximately 13 feet wide from the front side of the schedule to the clearly what we see the 13 feet wide for common entrance that is embrace and accuracy is possible here. One counsel is admitting the admitted that if the petition is based on common What is the injunction he is paying?
Injunction, Lordship,
Stated the
His
petitioner has
bearer,
absolute right to use the common entrance and car parking upon duty, and therefore the copy is refrained from causing any kind of nuisance, etc. to city in any in respect of his good use of let's see your sale lead.
Lordship, tell it is
tell it that
page 28, your lordship.
23. My certificate page 23.
23. An relevant portion at page 28.
28. Second para.
Which one?
Page 28, para, second para.
Page 23, it starts.
Yes, it starts the relevant page at page 28.
Your name is Surendranath Barua, Arman Ali.
Yeah, I am the
Arman
owner.
Ali.
Okay. You have purchased it and purchaser has approached the vendor and expressed desire to purchase the state plot of land together with the whole amount. 40 lakhs. Then there is a common entrance measuring 13 feet wide from the front side of the scheduled land, which starts from the main road to the ground floor of the southern side of the building, situated in the front side of the schedule. Of the schedule land starts from the gap of 5 feet from the existing wall of the Now tell me whether that person who sold it to you had the ownership over that common passage. Where? So his ownership.
Because originally, Lordship, this former dependent number.
Because what you have been sold is a plot of land measuring 2.81 R in so and so, standing thereon under so and so land, so and so, not so and so, in witness so and so. Then you kindly see what is being sold to you is in consideration of this so and so being the total price of land together with the house standing thereon paid to the vendor by the purchaser, receive hereby enclosed and conveys, transfer and assign the said land together they are absolutely to the purchaser so and so, and shall be vested in the so and housed with the houses and administrated. On the strength of the deed of purchaser shall be peacefully and hold in possession of so and so, shall do or execute all such deeds or things here, the vendor hereby delivers the vacant and undisputed physical and peaceful possession of the aforesaid plot of land together with all houses. Be noted if the purchaser so and so is deprived of so and so. The vendor hereby hands over the relevant documents here. There is a common entrance measuring approximately 13 feet from the front side of the scheduled land. So this is outside the scheduled land. Front side of the scheduled land. Outside. Which starts from the main gate of the scheduled land through the ground floor of the southern side of the building. So there is some building inside it, within it, situated in the front of the scheduled land. Okay. The eastern side of the scheduled land starts with a gap of 5 feet from the existing wall of the building standing on the eastern side. Purchaser would be at liberty to entitled to get the rent of a tower which have been used as so and so. So you have not been sold anything. What right do you have over that common passage?
No, Lord, common to use it. To access to my land. This is schedule B land.
So you now, are you saying that your ingress and egress have been stopped?
Yes, Lord.
No.
This is my.
Well, what happened, Lordship?
Let's see your plaint.
Yes.
What are you asking for? But you are asking too many. Why are you asking for many things? You should have asked only for that. My ingress and egress should not be stopped. You want to park there.
Park there.
What is the business of parking in the common entrance?
That is the problem.
What are you asking? Ad interim injunction restraining the so and so from causing any kind of nuisance, obstruction, annoyance, threat, and intimidation in the respect of the peaceful use of the common entrance of the land by being part and parcel of the scheduled land. How are you asking being part and parcel of the scheduled land? Mr. Counsel, withdraw the appeal. If I dismiss, the suit will be interfered. Will be very disastrous. There is no case. Your ingress and egress cannot be disturbed. That's all.
That is my main grip.
But all these obstruction, but you cannot park your vehicle there.
Yes.
That's true. But my
This is the problem. He is parking the vehicle. He is parking the vehicle in the park.
Common entrance of 13
That
feet.
is why Lanet trial got rejected his application, allowed my application.
Yeah. That is not possible. No parking business. You can only
Yes, ingress to ingress.
ingress and egress.
That can be.
Can only use it for ingress and egress, which the defendant shall not obstruct.
No, sir. We are not going to.
However, the plaintiff or the appellant shall not park his vehicle.
Yes.
Okay?
Lordship.
Now, the instant appeal arises against an order dated 28/2/2017 passed in Ms. case number 413/2016 entitled suit number 279/2016 whereby the learned trial court had rejected the application for injunction as sought for by the learned by the plaintiff petitioner, by the plaintiff oblique the appellant herein. This court have duly heard the learned counsels for the parties and also have inquired as to what is the stage of the suit, taking into account that the suit was filed in the year 2016 and presently the appeal is being taken up in the year 2024. Mr. R.K. Bhuya, the learned counsel appearing on behalf of the respondent, submitted that the suit is at the stage of evidence. Be that as it may, this court have duly taken note of the deed of sale bearing sale dated 11/1/2013, on the basis of which the plaintiff oblique the appellant claims his rights to file the suit. The issue involved is not in respect to the land which was conveyed by the deed of sale, but the issue pertains to as regards the use of the common entrance measuring approximately 13 feet wide from the front side of the scheduled land, which is the land which was conveyed, the learned counsel appearing on behalf of the appellant submits that though the plaintiff appellant have filed and had used to park its vehicles over the common entrance, but the opposite party used to disturb, for which he had been compelled to, the plaintiff had been compelled to file the institute the suit and seek for injunction. This court, taking into account that the instant appeal arises out of an injunction order and the limited scope, is of the opinion that limited scope. Injunction and the scope of interference by this court is limited. Be that as it may, it has been submitted by the learned counsel appearing on behalf of the appellant that the plaintiff uses this common entrance for its ingress and egress to the suit land, to the land conveyed by the deed of sale. And he submits that till the disposal of the suit, the ingress and egress of the plaintiff to the said suit land should not be disturbed. The learned counsel appearing on behalf of the respondent submits that the respondents have no objection, has not disturbed the ingress and egress of the plaintiff to the land conveyed by the deed of sale, but however has objection in the parking of the vehicles by the plaintiff over the common passage. Taking into account the above, this court passes a limited injunction till the disposal of the suit that the respondent shall not disturb the ingress and egress of the plaintiff to the scheduled land, to the land to the land,
Schedule B of the claim.
the schedule
B of the claim.
to the schedule B.
That is his purchase land.
To the no. The counterclaim also.
The counterclaim is there. Counterclaim in respect of lordship. Counterclaim, your lordship.
No, he is asking for schedule. No, schedule A1 is the post-storage building. No,
Right. As per his claim, this one, schedule B is his purchase land.
where is his plane?
Plan is that lordship page 11. It starts page 11.
Page 11.
Lordship, annexure 1.
Schedule were at page 19.
19.
To the schedule B land. Full stop. This court, however, makes it very clear that during the pendency of the suit, the plaintiff shall not park his vehicles in the common passage. Full stop. With the above, the instant appeal stands disposed. 2000. Yes, small matter.
Item 6, my lord, the matter has already been, my lord, amicably settled between the parties, my lord. And I have received the receipt instruction to withdraw the, my lord, money is put, my
Mr.
Arsham.
Mr. Arsham, appearing on behalf of the appellant, submits that he have been informed by the appellant that the matter has been amicably settled, and as such, he may be permitted to withdraw the instant appeal. So, taking into account the above, the instant appeal stands withdrawn, stands dismissed on withdrawing. Interim orders, if any, stands vacant.
All right.
Small matters. What matter?
Hello, that is the matter with the land.
Oh, yes.
So the government
That
was
is
supposed
too
to
late
face
for the
some
day.
instruction.
These people have not come. So we'll have it on some other day.
Yes.
Item number 10, we'll have it on. Let's have it on 13th of May.
My lord.
So item number 17 may prefer date, your lord. Item number 17, your lord.
Wait. Let us finish this first.
Lord.
Oh, jumping out. Mr. Barbuzari, this item number 10, let's have it on 13th of May. Let's see, gets an update what has happened. In the meantime, you have given him the patta?
Yes.
Yeah, the patta. Let's have item number 10. These some matters I remember by heart. I don't require anything.
We are obliged, my lord.
Hey, you got your patta.
Lordship can keep this as a part of the record. I am exchanging it, my lord, with my colleague. I am exchanging it with my colleague, my lord. And then, my lord, Lordship.
Where's the patta? Patta, he has to sign it, na?
Yes. Patta, my lord, I have inquired with the authorities. They say, my lord, that
Yes.
patta will be issued, but it takes a little time because now the record has been corrected. Lordship, if Lordship is taking that bunch of papers, Lordship may kindly come. My lord, Lordship will find a trace
No,
map.
we are concerned with 3668.
This is a trace map.
3664.
Trace map has been prepared pursuant to my lord's direction.
And new patta has been made.
New patta, but here, my lord,
But they have to, because that day, while passing that order, I remembered one thing. They have to, I forgot, I in fact told you also, no? That you have to go there and sign out there, because without signing, you cannot get the patta. Because the patta, you have to sign out there, and you see in the patta, when it is given, the signature of the pattadar is there.
Yes. Now, My
Because
lord,
I forgot on that day when I passed the order.
lordship may pass a direction to that effect and fix this matter on 13th. In the
Along with the
meantime,
other one.
and
I don't want the being a bench one judge. I don't want to disturb the bench 5 councils here. I don't.
no, my lord, we are obliged, my lord, time and again. We are obliged.
Yes.
Now,
Okay.
my lord,
In order to file to
this original writ petitioner Madhuri Chaudhary, she has expired. The next of details of the next of kin that my lord that appeared in the next of kin certificate as well as a list, my lord, given by the petitioners. Everybody's name has now been incorporated, my lord.
Name has been included.
Yes, yes, all the legal heirs, all the
But
legal heirs.
they have to go and meet the,
Yes,
when should they go and meet for the purpose of signing? Some days, some week, because we are now in the midst of an election.
Yes.
Now this is on 7th.
Yes.
Let's have it sometime on 28th of May, 20.
20 May.
20.
20 May, and in the meantime, my lord, after
Let them go, let them approach the deputy commissioner
Deputy Commissioner, my
or the circle officer. Who is going to give the patta?
patta is to be given by the Deputy Commissioner.
Deputy commissioner. Let him approach the ADC or something.
ADC revenue.
ADC.
ADC revenue lordship can fix it for that purpose on 28th of April. It will
Before
be Saturday.
20.
20 April.
Before the ADC revenue at 11 o'clock.
11 o'clock.
Okay.
I will communicate.
This court, by an order dated 13/3/2024, have directed the revenue department to give an updated status as regards the creation of the patta and the respective das in the 3 bighas of land, and also had given a direction that to prepare the patta along with the trace map and produce the same before this court. Pursuant to the directions, Mr. R. Pujari, the learned counsel, have placed before this court the trace map showing trace map as well as the certified copy of the Jamabandi
My lord. As well as the chitta.
and the chitta
My lord.
and the certified copy of the chitta, wherein a new patta has been created, being patta number. What is that?
Yes, well, this is my lord. Patta number 3664.
Huh?
No, my lord, it is 2640. 2640. That my lord will find in the chitta. My lord, the last but second page. Pottar number aru prokar 2640. Kheraz Meadi. Lordship got it, my lord.
Patta number. Huh?
Yes.
A new patta has been created, being patta number 2640,
My lord.
in favor of the next of the in the favor of the petitioners herein,
Yes. Corresponding
and corresponding to that number
3664. 3664.
Huh?
3664.
So there's a slack.
No, yes, it was the earlier tag number. That was my lord mistakenly created.
No, that pertaining to tag number
3664.
3664.
My lord.
Good stuff. The trace map have also been placed before this court, indicating the said land. Good stuff.
One supplication, if my lord allows me, my lord, the difficulty because it was a Asmali Patta. So it will find not only the petitioners out here, but other persons' name are also included. Now, if lordship direct that the Patta will be issued And if they only go and sign it, other persons may be left out.
No, understood. No, one thing is this.
Because it is as Malipata, total quantum of land is, my lord, in the original dark number, it was, my lord, 6 bigha.
No, here it is left, na?
No,
3
here
bighas.
here it is left. It is
3 bighas belong to them. No,
No, they only 2 bigha 10 lesser belong to them.
2 bighas, 10 lesser.
Yes, this is the period case.
It's okay. Then also you can give the patta. Certified keeper you can be given. You see, patta, only one pattada's signature is required. You don't require all pattada's signature. What it is given is pattada or sohi, and then down below aru. Oh. So it is done now. So don't worry.
My lord. And they have
The same are kept on record.
My lord, kindly.
The same materials are kept on record and marked with a letter. B. This court further is aware of the fact that there is a ensuing Lok Sabha elections. And as such, the Office of the District Commissioner, this court, having heard the learned counsels, and is of the opinion that in order to get the patta, there is a requirement that the petitioners have to approach the revenue officials, the concerned revenue officers, so that the necessary signatures are being taken. Accordingly, on the instruction as submitted by Mr. R. Papujari, this court directs the petitioners to appear before the ADC Revenue,
My lord,
Kamrup Metro at Guwahati,
my lord.
on 24/2024 at 11 a.m. in his office, so that the needful can be done. List the matter again on 13th,
Little later, my lord.
25/2024 for a further update.
Thanks to
Item number 15.
my lord, I have
Wait,
already exchanged that bunch of papers with my colleague. He has received it. My
In fact, these original, he should keep it. Anyway, we'll hand him over with a seal cover. Yes, what is that?
Item number 15.
What is that?
This the hearing matter, Lordship. There's some urgency in the matter.
What matter urgency? There is no urgency. Second appeal.
Second appeal, Lordship.
Second appeal has no urgency.
Can a date be fixed, Lordship? Because on several occasions the matter has been listed. It's a matter of 2013, Lordship. Can it be taken up?
2013, we have not been able to finish up 2007
Yes,
matters.
yes.
You
I can
see,
understand, Lord. Can it be taken
You
up?
will have it on, you see, next week, this week, 14th, I'm tied up with many matters.
Court is, if it is possible.
Huh?
Court.
What? If you give some chance, somebody takes the moon or something like that. Absolutely no. We'll have it on sometime on, okay, we keep your request 7th of May.
7th.
7th of May.
Item 17, Lord, to tenancy matter. Tenants, spider notice, Lord.
Which one?
Item number 17, your Lord.
Pertaining to
Tenancy, your Lord. Tenancy. The
landlord tenant.
Lord. That is
Which
May-
matter?
Lord, may pray for date, your Lord. Item number 17, your Lord.
Did I hear it earlier?
No.
Then?
May pray for date, your Lord.
Okay. 7th of May.
Lord.
7th of May, election is there.
Lord.
Oh, 7, no. 9th of May.
Lord.
Lordship, then this matter, item number 15. In the month of April. After
Which matter?
Item number 15, Lordship, is a hearing matter. Just now it has been fixed on 7th. Can it be in the month of April, Lordship? 7th is the election.
Okay. 30. 30. 30 for you and 7 and 9 for you. 9-5.
Lord.